Ring the bell. Okay, Secretary will read Senate Bill 418. No, I'm sorry. We're going to redebate that one more time. No. How about we table that bill? No. Senate Bill 39 is up next.
Senate Bill 39 by Councilman the 45th and others. A bill to be entitled An Act to Amend Code Section 16-6-13 of the Official Code of Georgia Annotated relating to the penalties for violating Code Section 16-6-9 through 16-6-12 so as to increase penalty provisions relating to pimping and pandering. Mr. President, the Senate on Judiciary recommends that this bill do pass by substitute. Senate Judiciary. Senate Committee on Judiciary offers the following substitute to Senate Bill 39. To amend Chapter 6 of Title 16 of the Official Code of Georgia Annotated relating to the sexual offenses so as to increase the penalty provisions relating to pimping and pandering. To amend Code Section 42-1-12 of the Official Code of Georgia Annotated relating to the State Sexual Offender Registry so as to require registration on the State Sexual Offender Registry when an individual is convicted for a third or subsequent time for certain types of pandering and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the 45th. Present the bill.
Thank you, Mr. President. I bring before you a bill, Senate Bill 39, that was a substitute that came through the Judiciary Committee. And this bill involves increasing the penalties relating to pimping and pandering. And first of all, let me say thank you not only to the Attorney General Chris Carr, but also to the man standing behind me and all of the advocacy organizations that have worked on child sex trafficking, human trafficking, and labor trafficking. And they have a program, an advocacy group, a PR campaign that's going on now, and it's called End the Demand. And that's exactly what this bill attempts to do. It changes the penalties resulting in a felony punishable by incarceration from 1 to 10 years. A first-time pandering conviction means an aggravated misdemeanor. A second or subsequent pandering conviction results in a felony punishable by incarceration from 1 to 10 years. The most important thing it does for me and for the advocates that we have been working with for so many years on, it also includes an inclusion into the sexual offender registry. So with that, and it begins on June 30th of 2018. With that, I want to say a big shout out to all these advocacy organizations, Street Grace, all the way down. There's probably about 50 organizations that are working on ending human trafficking in the state of Georgia. We've raised our report card. When we first started out, we were D as in dog, and now we've been elevated much higher. And we're very excited about that, to let people know that the state of Georgia, that we're not going to tolerate human trafficking. And most importantly, we're going to stand up for the children that are victims of this tragedy. So with that, I'll be glad to answer any questions, or I'll yield the well. I ask for your favorable consideration of Senate Bill 39.
There are no questions, Senator.
Thank you very much.
All right, questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. All those in favor of the bill shall vote yea. All opposed shall vote nay. Secretary will unlock the machine. Well, I was reading On the passage of the bill, the yeas are 47 and the nays are 0. Bill having received requisite constitutional majority is therefore passed. Secretary will please read Senate Bill 460.
Senate Bill 460 by Senator Beach of the 21st. The bill will be titled an act to amend an act known as the Metropolitan Atlanta Rapid Transit Authority Act of 1965, approved March 10th, 1965, as amended, so as to provide for adoption of a logo and brand to include the term ATL by such authority by a certain date and for other purposes. Mr. President, the Senate Transportation Committee offers the following substitute Senate Bill 460. A bill will be titled an act to amend an act known as the Metropolitan Atlanta Rapid Transit Authority Act of 1965, approved March 10th, 1965, as amended, so as to provide for adoption of a logo and brand to include the term ATL by such authority by a certain date to provide for the publishing of standards for bus service for a fiscal year and for other purposes. That concludes the order.
Recognize the senator from the 21st to present the bill.
Thank you, Mr. President. Fellow senators, I bring before you Senate Bill 460, which is a companion bill to amend the MARTA Act of 1965 to allow MARTA to implement SB 386, which is the transit bill. Basically, what 460 does, it does three things. It allows for the adoption of the ATL brand and the ATL logo for their trains and buses by year 2023. It establishes publishing standards for bus service for a fiscal year. They do that now in DeKalb and Fulton. This just upgrades it for Clayton to be included into that and any other county that comes in. And amends requirements for transportation service contracts between the authority and a local government. This would allow MARTA to enter into contracts for service outside their current 5 counties that MARTA is allowed to operate. So if they wanted to do rail in one of the other 13 counties, they could. So MARTA is very supportive of these changes. Mr. President, if there are no questions, I yield the well and ask for your favorable consideration.
You do have a question.
Yes.
Chair recognizes the senator from the 40th for a question.
Gentleman yield.
Yes.
So in this particular bill, this doesn't authorize MARTA to get any additional funding, a half-penny increase in any of the counties?
None at all, and nor does that happen in Senate Bill 386, which
Thank
you
you
will
very
hear
much.
in a little while. Thank
Appreciate
you.
it.
There are no further questions.
I yield the will. Ask for your vote.
Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass by substitute? Questions on the passage of the bill by substitute. All those in favor, vote yea. Opposed, nay. The secretary will unlock the machine. Senator from 26, why do you rise?
I'd like to make a motion, Mr. President.
That's not in order till after the bill's voted on.
After the announcement of the vote.
Okay. On the passage of the bill, the yeas are 51, the nays are 2. This bill having received the requisite constitutional majority, it is therefore passed. All right, Senator, you're recognized for 26.
Mr. President, according to our rule book, at part 7, 2-7.1, I would like to ask that the Senate go into the committee of the whole to try to bring out Senate Bill 424. Not had a hearing on it. It's been in committee. I think it's an important bill. Today is the last day that a Senate bill can cross come on this floor and then go to the next house.
That bill's on the general calendar now, or is that in the Rules Committee?
It's not in the Rules Committee. It's still in committee.
Still in the Health Committee?
Still in the committee.
All right, spend just a minute. Let me look at the rule book. Senator from 31st recognized for an inquiry.
Thank you, Mr. President. When I read that rule, it seems to say that notice of intention to make such motion shall be given on the session of the preceding day. Was that part of the rule complied with?
Parliamentary inquiry, Mr. President.
Hang on just a second here. I hadn't memorized this rule book all yet, so let me take a look at it. We'll spin for 1 minute and I'll be back with you. All right, Senator from 26. The proper time in our order of business to make your motion would have been this morning after the points of personal privilege. So you're out of order at this time. Thanks also to the senator from the 31st who brings a valid point that to make such a motion you have to give 1 day's notice. So this would only be able to be heard on Thursday, which is beyond crossover day. What's your inquiry, Senator?
Mr. President, if I read the rule right, it said if such notice shall not have been given, the motion shall prevail if it shall receive the affirmative votes of 2/3 of those voting, provided, however, that the 2/3 shall constitute a majority of all the members elected to the Senate. Now, that's what the rule says.
That does, but let me direct you to Rule 4-2.1 on the daily order of business. The timing of you making this motion would have
Four
been
dash what?
4-2.1, subparagraph 17, tells you when you should have made this motion. And that was before.
Motions to withdraw bills or resolutions from one committee, a committee to. I'm not asking. The only committee I'm asking for is the whole the entire Senate. I'm not trying to send it to another committee.
You are. You're trying to take it out of a health committee into the committee of the whole, and you are too late to file that motion. Whether you have a 2/3 vote or a majority vote, that motion.
Parliamentary inquiry, Mr. Speaker. Mr. President.
I recognize Senator 26 once more for parliamentary inquiry.
What other rule do we have if you can't get a bill
Got a book
heard?
full of them. There's no remedy for you at this time.
So, in other words, 2.7, which talks about the process, there is no other option for a senator to get a bill out of committee or have the entire Senate to hear the bill.
Not at this time in our order of business. Could have done that earlier. I'm sorry, Senator. Recognize Senator from the 41st for a question.
Mr. President, first parliamentary inquiry, and I'd like to make a motion. Is it not true that we can suspend the rules with a 2/3 vote, and we could suspend the rules on this matter with 2/3 vote, the same vote that he was asking for his previous motion? So I would like to move at the proper time to suspend the rules and allow that bill to be brought forward.
Your motion would be to suspend the rules, the order of business, to allow him to make a motion to recommit a bill from Health Committee to the Committee of the Whole out of order?
Yes.
Okay. Chair recognizes Senator from the 45th for parliamentary inquiry.
Parliamentary inquiry, sir.
Proceed.
Sir, is it not true that you're circumventing the committee system, and by going around the Health and Human Services and bringing a bill back out and putting it back into another standing committee, this is crossover day, and that I agree with your ruling? Is that not true?
Senator knows of which she speaks. I agree. This does circumvent your Health Committee if the motion were to carry. Senator from the 26th is recognized for another parliamentary inquiry.
Mr. President, isn't it true you're not circumventing the committee if the committee won't hear the bill?
Senator realizes that our committee chairmen are vested with great discretion as to what priorities to place on the bills pending before them. And I'm sorry you didn't get your way on this committee, but keep trying. There are a lot of other options. You may find a vehicle for your bill before it's all over. Chair recognizes Senator from the 1st.
Mr. President, I make a motion that we call the question from the senator from the 41st,
Yeah.
I'm sorry.
You're talking about the 41st. I'm not positive he's made that motion yet. Do you still wish to make a motion to suspend the rules to allow this motion to recommit a bill out of order?
That motion would be ordered, Mr. Chairman, to suspend the rules. I believe Senator 26 wants a motion that would be give him the option to bring that bill forward. So
right.
I'll make that motion on behalf
All
of
in
Senator 26.
favor? Hang on. I recognize Senator from the 45th first for parliamentary inquiry. You need to hit your button there, 31st.
Parliamentary inquiry.
Proceed.
Is it not true that there are many bills that did not get heard, but by circumventing the system, that there are down ticket motivations for bringing these bills up that have severe consequences, and those consequences need to be studied in committee and not right here on the floor of the Senate?
Senator knows which she speaks. I recognize the senator from the 31st for a parliamentary inquiry.
Mr. President, isn't it true that if the motion by the senator from the 41st were to prevail, it would be to suspend 2 rules?
That's correct. All right, now look here. We're going to vote on this in a minute. I'm going to recognize senator from the 26th, and then we're going to vote.
Parliamentary inquiry, Mr. President.
Senator from 26 recognized.
In all due respect, isn't it true 424, House Senate Bill 424, the only thing it does is creates an innovation center for these rural counties with these hospitals about to close, to be able to go to somebody that has the wherewithal to help them find the necessary money and finances to keep these hospitals open, and it would have to be a contract through DCH. That's the only thing that bill does.
Yeah. Senator, I know you have great passion. I grew up in Middle Georgia with you, and I know what you're trying to do. There are going to be other opportunities in the process, but first we're going to see if this body is willing by a 2/3 vote to waive the rules and allow you to proceed with it today. Senator, first, you don't need to make the motion. The question is being called right now. All in favor of suspending the rules will vote yea. All opposed, nay. This is to suspend the rules to make the motion to withdraw or commit from one committee to the committee on the whole. That's your vote, is whether or not to suspend the rules to allow that. Secretary, unlock the machine. Chair recognizes Senator from the 53rd for something. Point of inquiry, parliamentary
inquiry. A parliamentary inquiry, Mr. President. Looky here. Isn't it true that the senator from the 49th is glad he's out of the room when the lieutenant governor left?
That is very true. The wheels do tend to come off when the lieutenant governor leads us. We prosper under his guiding hand. Chair recognizes Senator from the 45th for a point of parliamentary inquiry.
Is it not true that we need a red vote on this to keep the order in this body? It's very evident.
Try my best, Senator. Senator from the 49th, can you help me? Got a question yourself?
Mr. President, isn't it true that a senator from the 53rd knows of what he speaks?
Look at here.
This is
I
bad.
think
Wait
he
till
does.
next year.
Let's look at here at this board and we'll know. Yes, he does. The nays are 33 and the yeas. That motion fails. Now let's get back to business. Have we voted 460 yet? Who was making that inquiry? I made him wait till after the vote. Secretary will read Senate Bill 232.
Senate Bill 232 by Senator Gooch of the 51st and others, a bill will be titled an act to enact the Facilitating Internet Broadband Rural Expansion Act to amend Titles 36, 46, 48, and 50 of the OGA relating to local government, public utilities, and public transportation, revenue and taxation, and state government, respectively, so as to provide for broadband service planning, deployment, and incentives for other purposes. Mr. President, the Regulated Industries and Utilities Committee offers the following subject to Senate Bill 232, a bill entitled an act to amend Title 46 of the OGA relating to public utilities and public transportation so as to specifically authorize electric membership corporations and their affiliates and subsidiaries to provide emerging communications technologies to provide, change certain definitions, and for other purposes. Amendment 1 by Senator Gooch of the 51st and others offers the following amendment. Amend the substitute Senate Bill 232 by deleting lines 84 and 85, inserting in lieu thereof the following. Conditions for the offering of broadband services, VoIP, or wireless services by inserting a quotation mark at the end of line 180 and deleting lines 181 through 184. That concludes the order.
Chair recognizes Senator from the 51st to present the bill.
Thank you, Mr. President, colleagues. Today I bring to you SB 232. It's another bill that we have dealing with a very important issue we've talked a lot about lately, and that's rural broadband internet access in rural Georgia. SB 232 simply allows the electric membership corporations in Georgia to provide broadband services within specific areas. Today there are 41 EMC territories across our state representing approximately 4 million customers. These 41 EMCs are governed by members that are elected by their residents and their users of their utilities, and they make decisions at the local level. This legislation will open up the code section to allow them to make the decision as to whether this is something they want to do in their communities or not. It will not allow them to subsidize the operation from their current electrical services or their natural gas funds, shall they choose to do that as well. Some EMCs offer natural gas, some do not. There is language in this bill that would prevent cross-subsidization of those separate entities. I believe competition is a good thing in a free market, and I believe this bill will go a long ways toward offering those opportunities for our rural areas, and I encourage you to vote for this bill. And Mr. President, I'll yield the floor for any questions.
You do have a question. Chair recognizes Senator from the 15th.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Senator, isn't it true that I strongly support your efforts that you've been making this year and last year and to serve those areas that are underserved or not served at all?
Yes, sir, and I appreciate
broadband.
your support.
To ask you a question, to get clarity on this, this does not circumvent or come on top of the cities, various cities' regulation that they cannot regulate their poll services and things like that.
Yes, sir, that is correct. You are referring to another piece of legislation we'll discuss later today.
Okay, but this does. I thought I read a part in this says dealing with the rent poll space to other EMC, but that's to other outlets.
Repeat your question. I didn't understand.
I thought I read a part in this. EMCs would have to continue to rent poll space to other provisions.
Absolutely.
Yes. Okay.
Yes, sir. They
on
cannot.
On a neutral basis.
The EMCs will not be able to discriminate against other providers. So they have a private agreement for their pole attachments for other companies that provide the same service. They cannot prevent those companies from attaching to their poles, because they have a separate agreement to allow them to do that.
And does not infringe on cities.
That's correct.
Thank you.
You spoke to the amendment, right, Senator?
I have not. There is a friendly amendment on the board that should be on your desk. It basically restores some of the language dealing with voice over IP, and that was at the recommendation of the PSC. It was inadvertently put in there. If we'd adopted that rule, then it could have deregulated the telecommunications industry, and some of the folks outside would have liked that, but I don't think that was the intent of the bill. And we deleted lines 181 through 184, which was to grandfather 2 EMCs in North Georgia that already deploy broadband, but they're under the authority of the TVA, which they're already exempt from these regulations anyway, so we deleted it just to keep folks happy up in the mountain districts.
No further questions,
Thank
Senator.
you.
Okay, the question is on amendment number 1, authored by the senator from the 51st, along with the distinguished senator from Macon, Bibb County, senator from the 18th. Is there objection? Without objection, the amendment is adopted. Now the question is on the adoption of the committee substitute as amended. Is there objection? Without objection, committee substitute as amended is adopted. Now, does any other senator wish to speak for or against the bill? Is the objection agreed to report of committee which Farrell passed the bill? Chairs none. Report of committee is agreed to. Shall the main question be now put? The objection. Chairs none. Main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. And the secretary will unlock the machine. Man, what did y'all have for lunch? Good night. Bipartisan action going on. They've been drinking some kind of Kool-Aid. I don't know what it is. But on the passage of the bill, the yeas are 55 and the nays are 0. And this bill, having received a requisite constitutional majority, is therefore adopted. Secretary will read Senate Bill 318.
Senate Bill 318 by Senator Redd of the 33rd and others, a bill we titled an act amendment Title 37 of the OCGA relating to mental health, so as to provide for the execution of a physician certificate for emergency examination of a person for involuntary evaluation and treatment for mental illness or alcohol or drug abuse based on consultation with an emergency medical technician or for other purposes. Mr. President, Senate Committee on Health and Human Services offers the following substitute to Senate Bill 318, a bill we titled an act amendment Article 1 and Chapter 1 of Title 37 of the OCGA relating to general provisions relative to the governing and regulation of mental health, so as to establish a pilot program to provide for the execution of a physician certificate for emergency examination of a person for involuntary evaluation and treatment for mental illness or alcohol or drug abuse based on consultation and for other purposes. That concludes the order.
Chair recognizes Senator from the 33rd, distinguished Senator from Cobb County.
Thank you, Mr. President, fellow senators, colleagues, friends, and y'all. Today I present to you Senate Bill 318. Under the current law, a physician may execute a certificate that he or she has personally examined a person within the last 48 hours, and based on those observations, find that the person appears to be mentally ill and require involuntary treatment. What this bill does is it requires the Department of Community Health to establish a one-year pilot program ending in July 1st of 2019 to allow for the execution of a physician's certificate for emergency examination of a person for involuntary evaluation and treatment for mental illness or alcohol drug abuse based on the consultation with the EMT or paramedic who has personally observed the person. The Department of Community Health must establish the parameters of this program and seek input of local emergency personnel, hospitals, mental health professionals to design the program. The Department of Community Health is authorized to select at least 2 counties in the urban areas for participation in this program. This program is created to determine the effects and outcomes for persons in crisis emergency receiving facilities, first responders, and the public in the implementation of the broader authority to issue certificates. After such person in crisis is delivered to the facility, a physician examination should occur and a certificate issued if warranted. I'd like to thank the senator from the 45th and the senator from the 11th for working diligent with me to craft this bill. And Mr. President, if there's any questions, I'll take them now.
No further questions, Senator.
Thank you. I yield well.
Question on the adoption of the committee substitute. Is there objection? Without objection, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Grant report of committee which fail will pass the bill. Chairs none. Report of committee is agreed to. All those in favor of the bill will vote aye. Those opposed, no. Secretary, unlock the machine. On the pass of the bill, the yeas are 54 and the nays are 1. This bill, having received requisite constitutional majority, is therefore adopted. Secretary will read now Senate Bill 450.
Senate Bill 450 by Senator Payne of the 54th and others, a bill entitled an act to amend Code Section 2739 of the OCGA relating to unlawful enticement of game so as to remove definitions relating to unlawful enticement of game and hunting in the vicinity of feeder bait and for other purposes. That concludes the order.
Chair recognizes the Chair recognizes Senator from the 54th. Oh, my. I forgot about that. Seems like this Northwest Georgia senator has his first bill up in front of the Senate today on crossover day. By the hair of his chinny chin chin, he gets here.
Thank you, Mr. President. Senate Bill 450, this is really a simple change. It's not a complicated change. It's really just to take what was once passed by this legislative body in 2011. The legislature voted to pass HB 277, which allowed for supplemental feeding of deer in Georgia. And that was signed into law. That bill, however, only permitted supplemental feeding in the southern half of the state and not the northern half of the state. Simply all this bill does is it opens up the rest of the state to the law that was passed in 2011 to allow supplemental feeding and the distance requirements applied to all the state of Georgia. Since supplemental feed was introduced to South Georgia in 2011, DNR reports no significant change in the number of deer that have been claimed each year in South Georgia. And in a recent poll conducted by the Georgia Outdoors magazine, 76% of respondents favored this change in the Georgia law. Georgia Hunting and Fishing Federation supports this bill, Senate Bill 450, and I ask for your consideration. Now, if there are no questions, Mr. President, I will yield the well.
Well, Senator, you're not going to get to yield the well for a while, it appears. That simple little bill that you described, they all come to the well and say how simple it is. But we are talking about Bambi, if I recall. And when that happens, there's going to be a lot of questions, particularly from one of your nice Northwest Georgia. I'm sure there's a friendly question. Senator from the 53rd has some questions. He'd be recognized this time.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Now, this issue is about baiting, isn't it?
Yes, sir.
There are many levels in this issue, and as an expert, would you say?
You're an expert, yes, sir.
No. Would you say that you're a master level on this issue?
No, sir, I would not say I'm a master on this issue.
Now, this is a serious question. Now, doesn't this bill just make it levels the playing field for hunters throughout the state of Georgia?
Yes, sir, that is absolutely correct.
In South Georgia, they're allowed to do more things for hunting to attract whatever animal they're hunting to a certain area.
Absolutely.
And in North Georgia, isn't it true, we don't have the same privileges as they do in South Georgia?
That's absolutely correct, Senator.
All right, well, let me commend you on leveling the playing field on this issue, and isn't it correct the senator supports this issue?
Yes,
and
sir.
isn't it more correct that I appreciate the master level that you present in this baiting issue? Thank you.
Thank you for your question.
Very, very good. Senator has a lot of experience in baiting, it seems. Chair recognizes Senator from the 56th, Public Safety, which obviously bill would be in its jurisdiction.
Thank you, Mr. President. Will the senator yield?
Yes, I will.
I noticed the senator from the 53rd obviously supported your bill because he didn't ask you about moral turpitude.
No, sir, he sure didn't. I was expecting it, though.
So we were just looking, you're newly elected to the Senate here in the last year or so. Is that not true?
Yes, sir.
Will you yield for a series of questions?
A limited series.
Well, thank you, Senator. A few of us were just looking over some of your campaign materials. And nowhere on your campaign materials is a talk about this being your top priority and your first need of your bill for your constituents. Can you tell us why this made it to the top of the pile?
Because of the moral turpitude, to make sure that we're doing the same for this north end of the state as we are for the south.
And Senator, can I direct you to Section 2, line 20, please?
Yes, sir.
Can you read that line to me?
All laws and parts of laws in conflict with this act are repealed.
Can you, Senator, if you yield for one more question, can you please explain to this Senate body the laws that were in conflict that you decided to repeal without letting any of us know?
I have done thorough research, and there are no laws in conflict with this. So
Well, then, Senator, why did you put that line in this bill?
because it's just in case something else comes about that I wasn't aware of.
Well done, sir.
Well, another North Georgia, somewhat North Georgia, senator from the 9th, he'd be impacted by this for a question.
Thank you, Mr. President. Did you ask the governor about this bill to see if he approved?
Yes, sir, I will yield.
Will you yield? Excuse me. Will you yield? As the governor's floor leader, I wanted to know if you asked the governor about this bill.
No, I did not ask the governor about this bill.
You didn't need to. I do have one other question. I'm not a big hunter, as this body knows. I have been hunting before. What kind of supplements do you give deer? You're talking about supplemental feeding. What kind of supplements to deer?
It could be corn or any other apples. Other things that deer eat would be supplemental feeding. That's not there by nature.
So these are natural things you're giving. You're not giving them chemicals or
No, sir.
other sort of supplements you may buy at GNC or something like that.
Whey protein.
Whey protein. Thank you.
Thank you.
Chair recognizes the minority leader, senator from the 41st.
Uh-oh.
Senator Yield?
Yes, I will.
Senator, is it not true that chronic wasting disease, a disease that affects the deer population, has been found in Mississippi?
I will take your word for it.
Is it not a consideration, or should we consider, Senator, whether or not we should encourage the baiting of deer when one of the protocols of dealing with this disease, should it be discovered in Georgia, is to not to bait the deers and get them together?
Well, I would say, Senator, those were the same concerns that were given in 2011. But the good thing is that now we have several years of, if you want to look at it as an experiment in South Georgia to see how this would affect the deer population. And it has not, none of that has come to fruition. So I think that like I stated earlier, the number of deer we're taking has not been increased, and there's not been any disease or concerns of that issue come forth either.
Senator, further yield?
Yes, sir.
Is the senator a supporter of the sport of hunting and feel that, in a well-trained and educated way, hunting's good for our state?
Yes, sir.
Does it concern you all that according to polls, 77% of people in Georgia pretty much support either strongly or moderately hunting, but only less than a third, less than 30% support hunting over bait? Are you afraid that the perception is that hunting is not as an attractive sport and may somehow turn against hunting in Georgia if we expand this practice and make the sport seem less popular?
Well, I'm not aware of the poll that you referenced. As I stated, a recent poll by Georgia Outdoors magazine, 76% of those respondents favored this legislation.
Chair now recognizes the senator from Bibb County, senator from the 18th.
Thank you, Mr. President. Does the senator yield?
Absolutely.
Senator, my seatmate, the distinguished senator from Chickamauga, was very concerned and did not ask his question that he asked many folks with their first bill. And you seem very quick to want to answer that question, but mine's a little different. Could you tell us what the definition of turpitude is?
I believe the senator from the 32nd district answered that extremely well just yesterday or the day before. So I'll just.
That'd be great. Then, Senator, you could quote that for us and tell us what she said.
I would have to go back and review her statement, Senator.
Okay. Well, just one follow-up question. Could you tell us, Senator, what is immoral turpitude?
It'd be the opposite of moral turpitude.
And with very good answer, Senator.
Chair recognizes senator from the 29th. Over to your right.
Always on the right, Mr. President. Will you yield for a few questions?
Yes, sir, I will.
I just want to read from lines 8 through 11 here. Now, in your bill, it says that you're amending the bill by deleting subsection A, by redesignating subsection A1 as subsection A, by deleting paragraph 2 of subsection B, by redesignating paragraph 3 of subsection B as paragraph 2, by redesignating paragraph 4 of subsection B as paragraph 3. Now, are you trying to confuse us?
Well, Senator, being that you are a stellar attorney, I'm sure that those terms you would completely and fully understand. I have complete confidence in that.
Well, at line 12, I see that, oh, excuse me, do you yield for a further question?
Yes, I will.
At line 12, I see that you deleted A.2 and replaced it with A.1. What happened to A?
It's still beside B.
Thank you, Senator.
Chair recognizes the senator from the 16th. 16th, over to your left. Always on your left.
Oh, here we go.
Senator, will you yield?
Yes, I will.
Have you ever shot a deer before?
Yes, I have.
I'm concerned. We're trying to equalize, as I understand, that the north will be equal to the south. Is that what I understand this is all about?
Yes, sir.
It is. Well, I'm looking here in the summary, and it really kind of concerns me. It says, whereas those in the northern zone may only hunt if the hunter is at least 200 yards away from the bait. Now, number one, have you shot a deer over 200 yards?
Well, that's current law.
That's current law.
Right.
But have you shot a deer over 200 yards?
No, I can't say that I have.
Okay. And I want to know what kind of bait you're using, too.
Well, I've not used bait.
You're not using bait, okay.
I live in North Georgia.
You live in North Georgia. Okay, I wanted to make sure. Okay. Thank you, sir.
Chair recognizes the senator who knows a lot about the North, Northeast, senator from the 50th.
Will the senator yield?
Yes, I will.
Senator, I've been trying to kind of catch a pattern here with your vote thus far today, and when I look at the caption of your bill, the caption reads, unlawful enticement of game. Tell me how you could ever rationalize a yes vote for the unlawful enticement of game.
Well, that's to make the unlawful enticement of game become the lawful enticement of game. That's the purpose of this legislation.
Chair recognizes Senator. Say, huh. Chair recognizes Senator from the 25th for a question.
Thank you, Mr. President. Does Senator yield?
Yes, I will.
Senator, were you as surprised as I was that the Georgia Tech grad from the 9th said he wasn't a big outdoorsman?
Chair recognizes Distinguished Natural Resources Committee Chairman, the senator from the 7th, for a few questions.
Thank you, Mr. President. Will my distinguished colleague from North Georgia yield?
Absolutely, for a friend, I will.
Senator, I was reading through the legislation, and I know that you may point this out. I know that I am a co-sponsor of the bill. My concern, though, Senator, is for our friends in North Georgia in regards to this legislation, and I know you're working to try to push this through, but nowhere in here does it talk about when this becomes law and when our friends in North Georgia can actually exercise the rights that we're trying to give them. So, Senator, when would our friends in North Georgia be able to exercise the right that we're trying to give them?
When our good governor signs it into law.
Well, I hope you go down and see about it. Chair recognizes Senator from the 8th. Senator from the 8th, Valdosta. Please pay close attention.
Would the great hunter from North Georgia yield?
Yes, sir.
Could you tell me the difference between a buck and a stag?
I'm sorry?
A buck and a stag.
A buck and a stack?
A stag.
Stag.
Oh, buck and a stag. If you, never mind. I will leave that up to the senator's interpretation.
You're not curious?
Trying to understand yourself.
You're not curious?
Would you like to inform me?
Okay, that was entertaining. Chair recognizes the senator from the 26th.
Senator Yield.
Yes, sir.
Aside from joking, Senator, in one of the things that would happen with this bill is to be able to reduce the deer population in your area. And when you look at the statistics, isn't it true that when you look at the statistics in your area, that insurance companies are paying out enormous amount of monies because deers are running out tearing up cars?
Yes, sir. It is true. That is very much true. Thank you, sir.
Chair recognizes the senator from the 40th district.
Gentleman yield.
I will yield to my seatmate anytime.
Is it not true that after today you may have two former seatmates? Is it not true that that you may break precedent today for a freshman because you may actually get a lot of red lights on this particular bill?
Well, I would hope not, Senator.
Chair recognizes the senator from the 14th, another North Georgia.
Senator Yield?
Yes, I will.
Senator, would you explain to this body what enticement means to you?
Enticement?
Yes, sir.
Enticement means?
You have it in your bill, Senator, in line 14. It says, nothing in this code section shall prohibit any person placing, exposing, depositing, distributing, or scattering any corn, wheat, or other grains, salts, apples, or their feeds or bait as to constitute or lure or attraction or entice.
To entice is to entice, an enticement.
So are you in favor, Senator Yield?
Yes.
Are you in favor of enticement or are you against enticement?
The bill allows for that.
Okay, so I'm going to assume you're in favor of it,
Yes.
but yet, how did you vote previously on Senate Bill 39 earlier that had to do with enticement, Senator? Senator, you can yield the well at any time.
The
Thank you.
record speaks for itself.
Chair recognizes the senator from the 19th.
Does the senator yield?
Yes, I will.
Senator, you've laid this out as a battle between the rules of the North versus the South, right?
Yes.
And you've taken the position of the North, correct?
No, I'm.
Yeah. That's a very good point,
We're all good.
Senator.
If there are no other questions, I will yield the well.
There are more questions,
Okay.
Senator. I mean,
Okay, then I will yield the well.
Senator has yielded the well. Thank you, Senator. Does any other senator wish to speak for or against the bill? Is the objection read in the report of committee which fail to pass the bill? Chair is none. Report of committee is agreed to. All those in favor of the bill vote aye. Those opposed no. Secretary, unlock the machine. Chair recognizes the senator from the 53rd.
Parliamentary inquiry.
State your inquiry.
Isn't it true that this bill helps level the playing field in Georgia for Georgia's hunters, and the hunters in North Georgia would appreciate a vote to help equalize that for all Georgians?
Senator has great passion for which he speaks. Chair recognizes senator from the 9th.
Parliamentary inquiry.
State your inquiry.
Is it not true that I want to make sure that there's no confusion on this bill? The governor is in support of this bill.
Are you sure?
I'm sure.
Absolutely. On the passage of the bill, the yeas are 36 and the nays are 19, and this bill, having received requisite constitutional majority, is therefore adopted. Secretary will read Senate Bill 436.
Senate Bill 436 by Senator Strickland and the 17th and others. A bill we titled an act to amend Chapter 9, Title 15 of the OCGA relating to probate courts so as to change and modernize certain general provisions for probate courts and for other purposes. That concludes the order.
Chair recognizes Senator from the 17th. Present the bill.
Thank you, Mr. President. Members of the Senate, I bring to you Senate Bill 436,
This bill is a result of the work of our Council of Probate Court Judges in the state. They spent the last couple years looking at our probate code and updating the code to meet today's practices and doing some good cleanup in there. The only substantive change we made in this bill really deals with how we replace a probate court judge when there's a vacancy in their term. We actually set up a special election to replace a probate court judge, where currently under law the associate judge assumes the rest of that term. And with that, Mr. President, I'll be happy to answer any questions.
There are no questions,
I'll
Senator.
yield the will. I ask your favorable consideration.
Any other senator wish to speak for or against the bill? Is there objection? Agree in the Report of Committee which favor will pass the bill. Chairs none. Report of Committee is agreed to. Shall the main question be now put in? Objections. Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 0. This bill, having received Rex constitutional majority, is therefore adopted. Secretary will read Senate Bill 411.
Senate Bill 411 by Senator Jackson II and others. The bill will be titled an act to amend Title 45 of the OCGA relating to public officers and employees to create the Georgia Commission on African American History and Culture and for other purposes. That concludes the order.
Chair recognizes Senator from the 2nd to present the bill.
Thank you, Mr. President. Senate Bill 411 creates the Georgia Commission of African American History and Culture. The Georgia Commission of African American History and Culture shall discover, document, preserve, collect, and promote Georgia's African American heritage with a primary focus on educating the citizens of this great state about the significance of African American experiences in Georgia for the past 400 years. It shall be, this board will be 20 members appointed by the governor, lieutenant governor, speaker, and the Georgia Legislative Black Caucus. It shall meet quarterly. On or before December 31st, 2019, the commission shall issue a comprehensive report with recommendations about the Museum of African American History and Culture, and this report shall come before this body. I ask for your favorable consideration.
Thank you, Senator, for this very good bill. Does any other senator wish to speak for or against the bill? Is there objection? Agree in the Report of Committee which favor will pass the bill. Chairs none. Report of Committee is agreed to. Shall the main question be now put in? Objections. Chairs none. Main question in order. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the pass of the bill, the yeas are 49, the nays are 0, and this bill amplitude Rex constitutional majority is therefore adopted. Secretary will read Senate Bill 461.
Senate Bill 461 by Senator Stone of the 23rd, a bill with title and act to amend Chapter 10 of Title 43 of the OCGA relating to barbers and cosmetologists so as to change certain provisions relating to barbering and the occupation of a cosmetologist and for other purposes. Mr. President, Senate Committee on Judiciary offers the following Senate Bill 461, a bill with title and act to amend Chapter 10 of Title 43 of the OCGA relating to barbers and cosmetologists so as to change certain provisions relating to barbering and the occupation of a cosmetologist and for other purposes. Amendment 1 by Senator Stone of the 23rd offers the following amendment. Amend the substitute Senate Bill 461 by deleting lines 155 through 159 and inserting in lieu thereof the following. B, the board is authorized to adopt reasonable rules and regulations requiring the individuals issued licenses and for other purposes. That concludes the order.
Chair recognizes Senator from the 23rd to present the bill.
Thank you, Mr. President, senators. This is an agency bill brought to us by the Board of Cosmetology and Barbers. Clarifies definitions and procedures. For example, license is defined to include certificate of registration or documents issued by the director that permit the practices under these professions or the instruction of practices. It also refines the definition of aesthetics so that there do not include medical aesthetics, aesthetics related to entertainment, or retail cosmetics. Also clarifies that hair relaxing is included under barbering. It clarifies that the board does not have power to preempt local ordinances dealing with licensing, and it does not have to require approval of its rules from the health department. It clarifies that inspections by the board can occur at any times that businesses are open as advertised or when patrons are present. It specifies that exams for licenses can occur within 48 months after completion of classes leading to that. Also, it allows for additional classes by schools of cosmetology if they have a minimum of 5 students. And finally, it adds to the list of practices that can be enjoined if they are engaged in without authorization to include other areas that are covered under the code, including hair designers, aestheticians, nail technicians, master barbers, and barbers too. If there are any questions, I'll be happy to yield. Otherwise, I urge your support for Senate Bill 461.
No questions, Senator.
Thank you.
Question on the adoption of the committee substitute. Is there objection? Oh, I'm sorry, we have an amendment. An amendment authored by the senator from the 23rd, amendment number 1. Is there objection? Without objection, amendment number 1 is adopted. Now the question is on the adoption of the committee substitute as amended. Is there objection? Without objection, the committee substitute as amended is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection? Agree in report of committee which fail pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put, or the objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary, unlock the machine. On the pass of the bill, the yeas are 52 and the nays are 1. This bill, having received requisite constitutional majority, is therefore adopted. Secretary will read Senate Bill 386.
Senate Bill 386 by Senator Beach of the 21st and others, a bill entitled Enactment Chapter 8 of Title 48 of the OCGA relating sales and use taxes, so as to provide for an exception to the ceiling on local sales and use taxes, to provide for the imposition of a transit special purpose local option sales and use tax within special districts, to provide for other matters relative to the foregoing, to amend Chapter 32 of Title 50 of the OCGA relating to the Georgia Regional Transportation Authority, so as to create the Atlanta Region Transit Link ATL Commission, and for other purposes. Mr. President, Senate Transportation Committee offers the following Senate substitute Senate Bill 386, a bill entitled Enactment Chapter 8 of Title 48 of the OCGA relating sales and use taxes, so as to provide for an exception to the ceiling on local sales and use taxes, to provide for the imposition of a transit special purpose local option sales and use tax within special districts, and for other purposes. Amendment 1 by Senator Beach of the 21st and others offers the following amendment. Amend the Senate Transportation Committee substitute Senate Bill 386 by inserting between lines 117 and 118 in the following. C. Any county that is contiguous with a non-attainment area may, upon request by the and for other purposes. Amendment 2 by Senator Beach of the 21st offers the following amendment. Amend the Senate Transportation Committee substitute Senate Bill 386 by deleting line 504 and inserting lieu era of the following. Encompass all transit service providers within jurisdiction of the authority. Such branch shall include the acronym ATL. Amendment 3 by Senators Albert of the 56th and others offers the following amendment. To amend the Senate Bill 386 Committee substitute by replacing the word directors on line 457 with advisors, insert, and for other purposes. That concludes the order.
Chair recognizes Senator from the 21st to present the bill.
Thank you, Mr. President, fellow senators. I bring before you Senate Bill 386, which is a regional transit bill. Before I outline the bill, I do need to thank a few folks. I want to thank the senator from the 46th, the senator from the 51st, and the senator from the 37th for all your help on crafting this bill. I also want to thank the entire Transportation Committee. We heard this 4 times in committee, and I want to thank you all for all your hard work. And then I want to thank the entire Senate body. We have led on this issue for years, and I appreciate y'all's leadership. You know, when I was elected 6 years ago, I asked the Lieutenant Governor if we could do a study committee on regional transit. We passed a resolution. We established a study committee, and I chaired that. And before my first meeting, I hired a kid from the University of North Georgia to film me, and we took a trip from Kennesaw State to Gwinnett County, 38 miles. Took us over 4 hours. But what I really learned on that trip was this. I had to go to 3 different websites to plan my trip: CCT, MARTA, and Gwinnett. I had to pay 3 different methods of payment: cash, Breeze card, cash. I had to wait 30 minutes minimum between jurisdictional lines. So I learned that day we had a very, very fragmented system that doesn't work. And I will tell you, they were just not efficient and seamless. And if we're ever going to be a world-class region, I think we have to have a seamless, efficient transit system. So basically what SB 386 will do is create a unified system that will be seamless, efficient, clean, and most of all safe. This will be very customer-centric, allowing the citizen that wants to go from Marietta Square to the 191 building to be able to do that in an efficient and seamless way. They cannot do that at this point. So here's what Senate Bill 386 does. It only does a few things. First, using Greta as the vehicle, we established the Atlanta Transit Link, the ATL Commission. Greta will still have their board of directors. They'll still do DRIs, and they'll still do the Clean Air Act. But the ATL Commission will be separate within Greta, and they will deal with planning, funding, and construction of transit projects. The governor will be the chairman, and all counties that participate will have 2 seats on the commission. Folks, we didn't want to create another alphabet soup organization. Greta was the logical choice to use as a vehicle to house the ATL Commission. Secondly, any county within the Greta region, the 13-county Greta region, can go to referendum for a 1-cent sales tax dedicated to transit. We address this in lines 66 through 72, and in lines 119 through 129. You cannot do this tax if you're already doing a regional T-SPLOS. The good news is there is not a county within the Greta region that is part of a TIA T-SPLOS in the state. So this would be voted on by the citizens. The tax will sunset in 30 years. And as I said to the senator in the 40th in our other bill, Senate Bill 460, the current MARTA counties, Fulton, DeKalb, Clayton, will not be assessed another 1 cent. This addresses that. You can't, we want to address, as the senator from the 46 addressed this in our committee meeting, we don't want to pile penny on top of penny on top of penny. So if the county decides they want to go to referendum, they would serve notice to the municipalities in the county, the MARTA CEO, and request a meeting to discuss possible transit projects. Working together, they will establish a project list and vote on and it will be voted on by the county commission and submitted to the ATL commission for final approval. The ATL commission has 45 days to either approve or reject. And the reason we want the ATL to have the final say is so that we make sure that all these transit projects from county to county match up and sync up so we can cross from jurisdiction to jurisdiction in a seamless way. Third, a county coming into the ATL will enter into a contract with MARTA on any rail expansion. Now on the bus service, what we will do, the ATL Commission will issue an RFQ and an RFP for a bus service within the ATL region. We will have one unified bus operator, and they will be chosen by the ATL Commission. Finally, we as a state are not taking over MARTA or wanting to operate transit. This bill is very partnership driven. MARTA will stay intact, but by 2023, we will rebrand the unified system throughout the 13 county region to the ATL. I want to address these amendments. The first amendment is allows any county, this was the senator from the 47th came to me and asked me about this, any county contiguous that would want to come in, he said he's got a county outside of the 13 county region that would like to join. So that would give them the opportunity to go to the ATL Commission and ask to join the system. The second amendment is my amendment. All this does is it includes such branch shall include the acronym ATL. This just mirrors what we just passed in Senate Bill 460, the MARTA amendment. Amendment 3, I've asked the senator from the 56 to withdraw this. And I believe he has agreed to it, and I'll let him speak to it if he would like, but I've asked him to take this amendment and withdraw it. With that, I will just say this. Let me say this. What this bill does is very simple. I'm just going to repeat this. It brings the region together in a seamless, efficient, clean, and safe manner, a unified transit system, and it's good for the customer and the citizen here in Metro Atlanta. It creates the ATL Commission within Greta to facilitate planning, funding, and construction. It allows counties to come up with a project list and go to the voters for final approval, and it rebrands the entire system by 2023 to the ATL. Mr. President, if there are no questions, I will yield the well and ask for your favorable vote.
You have a couple questions. Chair recognizes the senator from the 40th for a question. 40th. We'll come back to the 40th if he, Chair recognizes senator from the 51st. 51st, do you wish to be recognized? We'll leave him too. Chair goes now. Nope, you ready?
I do have a question.
51st.
Senator Yield?
Yes.
I'm looking at your amendment number 1 with the senator from the 47th. If he wanted just one particular county with that availability, that flexibility, can we carve it out just for that one county? Because I'm afraid that there's going to be negative impacts if you allow this for every contiguous county in that region. How many counties are in this district now, and how many could it be if every contiguous county chooses to opt in? Do you have that number?
I don't have that answer. I would have to look at a map to see the counties that are next to it, and I'm not sure even which county the senator from 47th is talking about, but I will tell you, if someone wants to join and it does a join, I don't think that's a bad thing.
My concern is that no one in this room has heard that language before now.
Right.
And there are some impacts that it could have back home that we haven't talked to our constituents about, because some of us have made promises that transit would be in Atlanta and may not reach up to certain parts of the state. So you go home and tell them you voted for something that changes that, it may cause some of us some heartburn.
Well, but this would not happen unless the county wanted to come in, came to the ATL Commission, asked to be invited into the 13-county system.
I just want to try to keep your votes intact.
Okay.
Chair recognizes the senator from the 26th for a question.
Senator Hill.
Yes.
I'm looking at one amendment. I'm trying to figure out the names. Kind of hard for me to do. From the 21st and the 47th.
Which one? Amendment?
It's from the senators from the. It's the First Amendment, the 21st and 47th.
Is it 1, 2, or 3?
It's one.
1, yes.
AM 390223. And as I read the language, does this language allow the chairman of the board of any of the commissions who are contiguous to the counties that have already pledged to be in the intergovernmental agreement, allow for them to do the 1 cent sales tax for the transit and not be part of an intergovernmental agreement?
No, they would become part of the they would come to the ATL commission the way this is amended, and they would want to become part of the ATL commission, and that's, I had a discussion with the senator from the 47th. So then they would come in and they would be part of the system, and their penny would go back to them.
All right, so they would be part of the intergovernmental.
And they would do, so if they wanted to do bus service, they would come into and use the bus service that the ATL commission creates through that RFQ and RFP.
All right.
Chair recognizes senator from the 45th.
Could you tell me which Senator Gill?
Yes.
Could you tell me which amendment you said you were going to withdraw?
Amendment number 3. I've asked the senator to withdraw that.
Going to withdraw it? So, would the gentleman yield?
Yes.
Mr. Chairman, I was going to ask about amendment number 1, and then I wanted to ask you about amendment number 2. Amendment number 1, an example could be Gwinnett County was a part of a regional system, and Hall County is in the non-containment area.
Correct.
Then we could, or the ATL could ask Hall County to join, but wouldn't the Hall County residents have the purview to have a referendum?
Yeah, they would have
join?
they'd have to go to referendum and do the same things that Gwinnett would have to do or anybody else. Yes.
And on the second amendment, would you further yield?
Yes.
On the second amendment, it looks kind of innocuous, but my question is, Gwinnett County has a branding already, and Cobb County already has a branding, and now you're going to create another branding. Where is the autonomy of these big, large counties? Where is that in this amendment number 2? Because I'm not sure if I'm in favor of it.
Well, when we voted on Senate Bill 460 just a few minutes ago, that was all about the ATL logo and the ATL brand, and MARTA has agreed to rebrand, and I think it's important to rebrand, Senator. I think what it does, it refreshes. I know that in the past, a lot of people in Gwinnett and Cobb did not want MARTA. I think they would be more amenable to the ATL, number 1. And I'll give you an example. ValueJet, they were about to go out of business. They had the same chairman, the same board, the same company. They rebranded to AirTran, and 8 years later sold to Southwest and took off. So I just think this could be a refresh for the region. We fly into ATL. You get your suitcase, it's got ATL on it. It'd be nice to get on an ATL train, ATL bus, ATL express bus, ATL light rail, and have one unified brand, one unified system, because I will tell you right now, if you go downtown this afternoon, you will see a Cobb Link bus, you'll see a Greta bus, you'll see a MARTA bus, you'll see a Gwinnett bus, and it's just a hodgepodge. And I think that we could really come up with a system that is unified if we had one brand.
Just one last question. Would
Yes.
you further yield?
Yes.
Does that mean that all the buses in Gwinnett and all the buses in Cobb and all future buses, they're all going to have the same colors, the same logo, ATL?
Same. It would have the same ATL logo that the ATL Commission will produce, and they'll get that done by 2023.
Thank you.
Thank you. If there are no other questions, I'll yield the well, and I'd ask your support on Amendment 1 and 2.
I have one question, Chair, from the Senator from the 9th.
Yes.
Thank you, Mr. President.
Yes.
Will you yield?
Yes.
Thank you. I'm trying to get my head around amendment number 1.
Okay.
What happens if, because first question is, you can this is something you must opt into. A county
Correct.
must opt in, correct? So what happens if a county outside, contiguous with the non-attainment, opts in, but the county that is within the non-attainment area has not opted in yet? It does
Right.
kind of create a non-contiguous situation. How do we address that in that instance?
Well, that's a good question, and I really don't have a great answer for you. I'm not sure quite how that would work. I think we'd leave that up to the ATL Commission to figure that out. I don't know that the ATL Commission would want to bring in another county that's above or a county that's not within the system. To your point, if it's not if they're not already in the system, and I would think that they're not contiguous. Okay.
Will you further yield?
Yes.
Would we need to, I mean, would it make sense to add an amendment to the amendment to make sure that that's clear, that they can say no? I'm not sure that they can that they have to agree. It says may upon request, but I'm not sure that clarifies that they must agree.
No, they don't have to agree. The ATL Commission does not have to agree. They have to go before the ATL Commission to make the request. And just as the ATL can deny or approve a project list, they could deny or approve a county coming into the 13-county ATL region.
Okay, thanks.
Thank you.
Clear the senator from the 40th slide. I don't go ahead and
Okay.
clear it because he's not here. Do you have a question, Senator from the 37th? You're recognized for a question.
Thank you, Mr. President. Does Senator yield?
Yes.
Under Amendment 2, would that mean that all the MARTA facilities are branded ATL?
Yes. What we're trying to do, MARTA, we're not getting rid of the MARTA 1965 Act, MARTA Act of 1965. We're not getting rid of their local constitutional amendment. All we're doing, so they'll be the umbrella agency, but they'll be doing business as the ATL, so we have a unified logo and a unified brand throughout the system. Thank you.
Chair recognizes Senator from Coweta County, Senator from 28.
Thank you, Mr. President. Does the senator yield?
Yes.
We've got, you mentioned 14 counties. What, do you have a list?
13 counties.
13
and
counties?
the 13 counties are this. I'll read them off
That's
to you.
what I need. Thank you.
Cherokee, Clayton, Coweta, Cobb, DeKalb, Douglas, Fayette, Forsyth, Fulton, Gwinnett, Henry, Paulding, and Rockdale are the current counties that are in the Greta jurisdiction. Those are the 13.
Thank you, Senator.
Thank you.
There are no further questions, Senator.
Okay, thank you, and I would ask your favorable consideration and on Amendment 1 and 2 and not on Amendment 3, and vote yes for the bill. Thank you very much.
All right, the senator has spoken to Amendment 1 and Amendment 2. I would like to now go to Amendment 3 and allow the senator from the 56th at this time to speak to his amendment. So all the amendments will be spoken to.
Thank you, Mr. President. I'm going to speak to the bill and the amendment at the same time to save us some time. First, I want to thank the author for the work he has done for many years now, and especially in trying to come up with a compromise that will work. The purpose of Amendment 3 was to take that very large board of 14 members, which I believe would cause more time and bureaucracy than perhaps results, and move them to an advisory position and make sure the board was governed by people who could make more actionable decisions that would be appointed by the governor, lieutenant governor, speaker, and the chairs of the transportation committees of both the Senate and the House. In general, I think we have to have an important conversation of how we want to move forward and make sure we separate emotion from facts. And I want to make sure that Georgia's innovating to the future. For a long time, we talked about how do we solve the transportation and traffic problem, and there was no silver bullet. But that does, in fact, exist today, and that is with autonomous driving vehicles. They are not coming in years. They're here in months. In fact, all over the United States, in just the next couple of months, you're going to see people moved in Ubers and Lyfts, pizzas delivered to your house. We've already seen tractor trailers moving around the country, and it is the future. And I want Georgia to lead the way. And I want it to lead the way by a private market-driven solution. Government is not always the answer. In fact, we have an opportunity to embrace the innovation and technology and those entrepreneurs all the way up to the large car manufacturers, which every major car manufacturer in the world are launching fleets of autonomous vehicles in the next 1 to 3 years. We all have to agree on our priorities, and our priorities need to be to improve public safety and to move people quicker and more efficient than we did in the past. Oftentimes, we quote our reasons for doing this is our millennials. Our newer adult generation oftentimes says, well, they never want to buy a house and they never want to buy a car. But unfortunately, the facts prove out that the millennial generation is buying cars faster and more often than any generation before them, and the same with home ownership. We also need to make sure that when we invest in any type of an expansion of mass transit, there is a need. We cannot have another $100 million disaster like the Atlanta streetcar again. We also need to make sure when we base those needs that it's not on a promise of what's to come. Almost every major city in the United States, their mass transit riders are down. That includes the Washington, D.C. Metro, and that includes MARTA. And it has been that way over the past 10 years. We also have to be careful not to continue to look at ways to tax folks. We need to be looking at ways, like we did a little bit earlier today, on reducing taxes. It doesn't mean we don't need a comprehensive solution. And I love the senator from the 21st idea of branding, in communicating, and having a single place to go. These are smart, innovative ideas. And I sure hope that those buses going down the road in the future are driverless as well, because we'll eliminate the single largest cost for that system when they're autonomous. When we look forward, we also need to make sure whatever system we have is safe and reliable. And I need you to hear this story, because this happened in September, end of September this year. A MARTA train left the North Springs station with a whole group of people wanting to go to the Atlanta United game. They were fans and they were excited. They got under downtown, the lights went out and the train stopped. And there they stood. They picked up the phone and they called the MARTA line. Nobody answered. They called the MARTA police line. Nobody answered. After 10 minutes, where it was hard to breathe and very hot, the passengers pried the doors open of this train in the tunnel underground. 20 minutes later, they walked down the 18-inch gangplank, up an emergency staircase in the dark to pop up in Midtown to get an Uber or a Lyft, and most of them missed most, if not all, of the game. That happened 6 months ago, folks. We still have systemic problems, and we cannot commit to expanding something that is not functioning properly. Again, I want to commend the author because he's trying to do something right, but we need to make sure we have a foundation before we move forward. When I authored my amendment, I did make a slight error on the way that I had drafted it. I will, after I'm done talking, go spend a few minutes with the author in order to figure out a good solution, because I do want something to move forward. But that's something for where I live in Fulton County is no new taxes. For almost half a century, we have paid for a lot and got almost nothing. If they want to bring something else out, it will be with our existing tax dollars, not anymore. And I think that probably goes for my friend Senator from the 40th. There's an opportunity to do something, but we need to be smart and we need to do it right. Mr. President, if there are no questions, I'll yield the well.
Chair recognizes Senator from the 40th for a question.
Senator Yield?
I yield.
Senator, let me make sure I understand. DeKalb County has a SPLOST right now, which we use for primarily for transportation. We just passed it this past year. And on the other bill, I asked a particular question, is it not true that we can't increase the MARTA tax under this bill? Is that true?
I believe that to be true.
All right. What I'm asking you now, I currently have a SPLOST for 1%, 1 penny. Are you saying that this legislation means I could have another penny put in there for transit?
I do not believe that is the case, Senator.
Okay. So in that particular case, is not true, then your statement about increased taxes would not apply. Is that not true?
Senator, in this bill it may not apply, but you and I have been down here for a long time, and we know that these bills tend to be followed by the next bill and the next bill, or I'm sure as the House bill comes over, there's going to be a conference committee, and there are going to be changes made, and I want to make sure that we have set everything in a strong foundation now that that is not negotiable.
I understand. Thank you.
Thank you.
No further questions, Senator.
Thank you, Mr. President.
Okay, we'll move through those that wish to speak. Chair will first recognize Senator from the 45th. Speak to the bill.
Thank you, Mr. President. I'll try to be brief. And I'm still not exactly sold on all these amendments, and hopefully they're rewriting some of the amendments. But I do want to say, as a senator that represents Gwinnett County, a portion of Gwinnett County, northern Gwinnett County, I want to say thank you to my colleague from North Fulton who has worked so aggressively on this. And while I do not sit on the Transportation Committee, and I've never sat on the Transportation Committee because I have specialized in health care, but I will tell you this, I have always watched the Transportation Committee like a hawk, because if you ask me in my district, since the day I walked in this building and until the day I leave this building, the #1 issue in Senate District 45 is transportation. And all we have to do is look out these windows and see the congestion. All you have to do is turn on your news. All you have to do is listen to conversations, people talking about how much they hate, literally hate being in traffic. Gwinnett County's population has increased and will increase to 1.5 million by 2040, up from currently almost 1 million people, a 58% increase in 2040. Metro Atlanta, as you can see, when we come downtown, it will also increase in population. When we do our polling in Gwinnett County, and we do a lot of polling, we ask our senior citizens, what is the #1 issue and concern to you? The #1 issue is their ability to get to the grocery store and to get to the doctor's office. If you ask the millennials, what's your #1 issue? It's being able to get to school, whether it's high school or it's college or wherever they want to go. I'm not going to say the bars, but they have a very difficult time with their transportation. One of the things that we have talked about, and Wayne Hill is a former Gwinnett County Commissioner, and he said all you have to do is look out there on I-85 and see the problem. And the problem is every third vehicle is not a vehicle, it's a truck. And it's truck traffic and cargo that is moving through Atlanta. They're not supposed to go through downtown Atlanta, so they use 285, but they end up back on I-75 and I-85. Also, one of the things that we're concerned about is we have done a fabulous job with the port system, and we are so proud of our port. But guess what? That port, that cargo has to move. And how is it going to move? It's either going to move on the railroads or more commonly on the trucks. And those trucks are going to increase over the years. Local government has to be on board, and that is one thing that the senator from the 21st is doing a good job about, and that's one of our failures in the past. Local government and regionalization has not been a part of the conversation. I believe that Senate Bill 386 puts the choice back to start the conversation about expanded transit in the hands of local leaders. We have some great county commission chairmen. I know I'm very proud of my chairman who's out in the hall lobbying on this particular bill, Charlotte Nash. I'm very proud of her. But we have to involve those board of commissioners. We have to involve those city council members and get them into this regionalization concept. One of the most important things that we've done in Gwinnett County, and one thing that I'm very proud of, and I bet you out of all the 56 senators in here, I've probably paved more roads and built more roads. One of my claim to fame is Sugarloaf Parkway. We had Jimmy Carter Boulevard, we had the Ronald Reagan Parkway, and when I was on the Board of Commissioners, they said, okay, what are we going to name this? We're going to name it George Bush. And I said, no, nobody wants to live in a subdivision named Bush subdivision. They said, okay, Renee, you're so smart. What do you want to name it? And I said, when I was a little girl, I rode horses at Sugarloaf Farms, and now Sugarloaf Parkway is a very famous parkway. But one of the things that made us so successful with our SPLOST program was that we issued to the voters a list. We said, this is what we're going to do. This is our commitment. There's no politics involved. We're not going to change the list of roads, the list of bridges, the list of intersections. I compel this regionalization. You have to be transparent. People have to have trust in a regionalized approach. And Gwinnett County has been so successful with this, I ask you to copy and mimic that. I'm going to close out and say the state has to be a facilitator. You know, I've stood down here and I've pushed that red button and I pushed that red button. I worked with the senator from Roswell, the 56, to kill the bill 2 years ago about transit. I want to push the green button. I want to get out of the traffic that we're currently in. We have to do something. I want to push the green button. Do I think this bill is perfect? No. No, it's not perfect. Do I think the one in the House coming over, it might be a little bit better? But what I'm asking is, let's put these two together. Let's come together. Let's be able to say this is a historic year where we push that green button. I lived through the votes of the 70 in MARTA in Gwinnett County and the billboards and all the racial division. I don't want to go through that again. I think that we can do better. I commend the senator from the 21st. I'm willing to work with you. I'm very concerned about these amendments. We want our autonomy. We've spent a lot of money on these buses and our branding. I'm very concerned about the ATL breezing down that Sugarloaf Parkway. But I'm willing to work with you. I'm willing to work with you, but you got to work with us. And I think that's a two-way street. I think we're on the right direction. And with that, Mr. President, I'll yield the well.
Chair recognizes Senator from the 41st speak to the bill.
Thank you, Mr. President, members of the Senate. I just want to come down to thank the chair, the senator from the 21st, for working with all parties. You know, this is a complex issue. It's one that many Democrats and Republicans have fought for a long time to try to expand transit in our state. And I think as we look back, we know that one of the failures of previous administrations, Democrats and Republicans, have been that we didn't do more to prepare our transportation system and especially to promote transit as an option for Georgia citizens. We need to move far and we need to move relatively fast. That's going to take an investment and a commitment. So I hope that we will each commit ourselves to that goal. And again, I want to thank the senator from 21st for bringing something today that will help move our transit system and our transportation system in Metro Atlanta faster and farther ahead. I also want to remind each and every one of you that DeKalb and Fulton counties for a long time have invested in transit, in the transportation system, in MARTA, and are proud of MARTA. Now, we certainly, if we can expand the system, bring others involved,
certainly willing and happy to discuss rebranding the name. That can help. We also know there's cost involved, and we all need to share that cost. But we want everyone to know that we're not being objectionable to new ideas or to expansion when we say to you that it is important to DeKalb government and DeKalb citizens and Fulton County government, DeKalb County citizens, and now Clayton County government and Clayton County citizens, that the investment that they have put in to transit and transportation are protected and respected. That's why I would oppose Amendment 3 if it were to move forward, and oppose this bill if it were on there. But as the bill stands, I want to say that this can get bipartisan support, and as long as the author of the bill and others continue to work with the employees of MARTA, the workers at MARTA, the local governments that have invested so much, and the communities that have invested so much to make sure that we have what we do have in the infrastructure and transit and transportation, continue to protect them, as well as grow and protect and enhance other citizens of Georgia. We'll have a great working relationship and hopefully see a brighter and better day for Georgia. I yield the well if there's any questions. Not? Thank you, Mr. President.
Chair now recognizes the distinguished senator from Cobb County, from the 37th, the great bird slayer.
Thank you, Mr. President, members of the Senate. I'll try to be brief. I want to thank the senator from the 21st for his work on looking at transportation issues and problems that we face. I agree with the senator from the 45th, probably that's the biggest issue that we face in the Atlanta metro area today. However, for the last 45 years, Cobb County has been vilified by the press and others for what they call being backwards and stupid for not joining MARTA. It's also been said recently that Cobb County is not interested in seeking solutions to our massive transportation challenges, and this belief is absolutely not true. I'd like to set the record straight. I speak for myself and not Cobb County, but I think my views represent the people in my district. I wholeheartedly agree that between all of the 13 counties that are in the non-attainment zone and any adjoining counties outside of that, that there should be a framework for a collaboration to address and propose a solution to Atlanta's cross-jurisdictional connectivity dilemma. I believe it should be the goal of such group to first define the problems that they're facing and try to come to the most effective solution that would consist of the spines of major connectivity in routes and also in modes of transportation. I think this planning is critical to happen on the first, to occur on the front end instead of being a byproduct of this process. I do not believe it is wise for a county to be required to cede all local control of local transit to an organization of which they have very little influence on the outcomes and decisions of that organization. I'm not sure that a fixed 1% sales tax for 30 years is the best inducement to get counties to participate who may not feel that a 1% sales tax for 30 years is justified. That's a long time to devote 1% sales tax to solve the problems. And as the senator from the 56 mentioned, autonomous vehicles We're just on the cusp of seeing that. People have vilified Cobb for not coming in. I'm not sure that they want the company, but I am sure that they want the money. Let me tell you how that works. In 2016, tax yield on SPLOST dollars for transportation, that take would have been right at $140 million a year. That's starting today, and then whatever growth and whatever inflation there is over the next 30 years would be huge. But let me put that in context. In 2016 terms, that is more tax revenue than would be generated by Forsyth County, Cherokee County, Paulding County, Douglas County, and Coweta County combined, with an additional $8 million thrown in. So there's a lot of money to be had if Cobb signs up to this, or for this. But Cobb needs to be prudent, as every other district does. We also need to realize that there is no single solution to the traffic problems that we see today. I want to quote from a newspaper article from about a month ago, talking about the future of transit. It says, the task ahead is daunting. Name a city that has cracked the congestion nut. Chicago, it has the famed L, but is listed 8th most congested city in the U.S. Boston has its subways, but ranks 7th. New York lands in the 5th spot. Atlanta has MARTA and is 9th, according to the transportation analytics firm NREX. I think as we look at this, we need to affirm there is no single solution. I think we need to keep in mind GDOT's plans currently for 285, the northern portion of it, all of 285 north of I-20 on the east and west. Their concept for redevelopment of this, and they're developing plans as we speak, would improve the lane quantities and also the lane numbers to include managed lanes that would provide for transit vehicles to travel in managed lanes 24 hours a day in each direction. These would be open to all transit vehicles as well as paying customers who would pay based on the load of the road at that time. We need to look at all of these options. But the main thing I think we as a governing body of the state of Georgia needs to look at and come to grips with is that we finally need to acknowledge the fact and admit that we need an outer bypass around Atlanta. People say, well, how are you going to fund it? Well, I don't see any problem with tolling it, because I'll promise you, if I was in Chattanooga and I wanted to go to Savannah, I'd pay $20 not to have to go through downtown if I could run 75 miles an hour. An additional 15 or 20 miles would be a breeze for not having to encounter the congestion that we face. It's imperative that we separate the traffic going through Atlanta from the traffic going to Atlanta. And as long as we have all of the traffic going through Atlanta, we're going to continue to have congestion regardless of what the solution is. I'm all for finding solutions to our connectivity dilemma, and Cobb County is also. But it has to make good business sense for Cobb to get on board. This is probably the reason that Cobb has taken the course of action that it has for the last 45 years. Thank you, Mr. President. I yield the will.
Chair recognizes Senator from the 51st.
Thank you, Mr. President. I wanted to echo a few of the things that have been said up here today. I want to congratulate our chairman for the hard work that he's done for the last 2 years. We've been working on this. The Senate's been in the lead on this for several years now, working with the House over the last 2 years. We realize the problems are out there. We know what the congestion issues are in Atlanta, and I think we're off to a good start. And before we take this vote, I want to encourage everyone in here to vote for this bill, because it's not the final passage. I, too, think there are some issues, and I think the senator from Cobb eloquently spelled out several things in the bill that
he'd like to see, and some other issues with autonomous vehicles, ride share options. Those are things that need to be developed and incorporated into this plan. We're not voting on the plan. We're voting on the governance structure and the funding of it. And so I think we need to push the bill forward. You senators from Gwinnett and Cobb County especially need to support this, in my humble opinion. I would like to ask us to not pass amendment number 1. I think the chairman's going to repeal that. And the only reason is we don't know what the unintended consequences of that are. The non-attainment counties are very, very large. I just pulled up a map of that non-attainment area, and the contiguous counties around that encompass 20 other counties. And some of the wording in this makes it kind of vague as to whether those counties would have to be part of the regional transit system, or if they could just take that 30-year T-SPLOS or that transit money and put it on their own special transit projects. And I think we need to be very careful tying up those counties' funds for the next 30 years. Some of those counties go down almost to the Macon area and all the way up into the mountain regions of the state. So I would encourage us to repeal amendment number 1, pass the bill, continue to work on it, but when we get back with the conference committee, we need to look at ride share options and some other things that are concerning the senator from the 37th and the 45th and maybe the 9th. So, Mr. President, I just wanted to encourage people to continue to push this bill in the right direction. Thank you.
He has yielded. Chair recognizes Senator from the 9th. You just had a question. Senator from the 21st, close the debate.
Thank you, Mr. President, and I want to thank all of you for your comments. I want to thank the senator from the 45th. Appreciate your comments, and the senator from the 37th, and really appreciate your comments from the senator from the 51st. What I'd like to do is close out. I would like to withdraw my 2 amendments, Amendment 1 and Amendment 2, and I would respectfully ask the senator from the 56th to withdraw Amendment 3. I would like to pass this bill as a committee sub is passed out of the Transportation Committee. We had 4 hearings on it, and so I'm asking for all amendments to be withdrawn. With that, I will yield the will and ask for your favorable vote on Senate Bill 386. Let's send a message that we want regional transit. Thank you.
Chair recognizes Senator from the 21st to withdraw your amendments. All right, Senator is moving to withdraw Amendment 1 and Amendment number 2. Is there objection? Without objection, Amendment number 1 and 2 have been withdrawn. Now the question, or excuse me, Chair recognizes Senator from the 56 on Amendment 3.
Thank you, Mr. President. I ask unanimous consent to withdraw Amendment number 3.
Amendment 3 has been withdrawn. All amendments have now been stripped from the bill. Question now is on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree in the report of committee which fail pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? The objection. Chairs none. Main question is ordered. Shall this bill now pass? The question is on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 51, the nays are 4, and this bill, having received Rex constitutional majority, is therefore adopted. Would like to read the committee reports. Secretary will read.
Mr. President, the Senate Rules Committee, pursuant to Senate Rule 2-1.10b, has referred House Bill 918 by the Senate Rules Committee to the Senate Committee on Rules from the general calendars, respectfully submitted by Senator Moles of the 53rd. And Mr. President, the Senate Committee on Rules has had a consideration of the following legislation, instructing the same back to the Senate with following recommendation. Senate Resolution 149 do pass. House Bill 918 do pass by substitute. So by Senator Moles of the 53rd. That concludes the order. Thank you, sir.
Secretary will read Senate Bill 425.
Senate Bill 425 by Senator Gooch of the 51st and others. A bill will be titled an act to amend Title 43 of the OCGA relating to professions and businesses so as to change provisions relating to professional land surveyors, to change and add certain defined terms, to provide for land survey interns, to change certain educational and examination requirements, and for other purposes. Mr. President, the Senate Committee on Regulated Industries and Utilities offers the following subject to Senate Bill 425, bill titled an act to amend Title 43 of the OCGA relating to professions and businesses so as to change provisions relating to professional land surveyors, change, add certain defined terms, and for other purposes. That concludes the order.
Questions on the adoption of the... well, do we need to really listen to him? Chair recognizes Senator from the 51st to present the bill.
That's like when they say you had me at hello. It calls for the question. Senators, I have a bill before you today that has been worked on by the Surveyors Association in Georgia. This is an important industry to our state. This is a group of professionals that, unfortunately, we're losing interest in the industry. Surveyors do a lot of different things these days, but the primary purpose of a land surveyor was just to do that, and that was a boundary survey. In the recent years, they have begun doing design work, which is requiring them to take engineering courses. This bill simply breaks out their license requirements to allow them to get a license just to be professional land surveyors, to do simple land surveying work, and if they want to go into the other work that deals with the design work of detention ponds and water structures and so forth, they would have to be certified as a professional land surveyor with that designation on their license, which requires the engineering courses and the hydrology courses in a college. So that's pretty much all the bill does. I ask for your favorable consideration. I'll yield the well for questions.
There are no questions, Senator.
Thank you.
Question now is on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Granted, report of committee, which fail pass the bill. Chairs none, report of committee is agreed to. Shall the main question be now put, or the objections? Chairs none, main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 0. This bill, item C, Rex constitutional majority, is therefore adopted. Where are we?
Secretary will read Senate Bill 414.
Senate Bill 414 by Senator Tibbetts in the 37th and notice a bill be titled and act amend Chapter 17, Title 43 of the OCGA relating to charitable solicitation so as to allow local governing authorities to issue written notices for the failure to clean and maintain collection receptacles and for other purposes. That concludes the order.
I call upon the senator from the 37th to present the bill.
Thank you, Mr. President, members of the Senate. I'll try to be brief. Current state law allows for the placement of charitable contribution receptacle bins outside. They look very much like dumpsters. And in that, people bring donations for charitable organizations, be they profit or nonprofit, and put them in these bins. Since this is currently under the Secretary of State's jurisdiction, current law does not even provide that you have to have an property owner's signature or authorization for these bins to be placed. The problem with these bins is a lot of people mistake them for garbage bins, and they put garbage around them, mattresses. And I'll say this, the good organizations like Goodwill and Salvation Army and those that we know and maintain offices in Georgia, we have no problem with them. But we have some out-of-state organizations who have these bins, and they do not monitor them on a regular basis, and there's really no recourse. What this bill does is give local governing authorities, either counties or cities, the authority to send notices when there is a nuisance existing because of non-maintenance of the bins, and goes through a process by which these can be removed if the owner of the bins are non-compliant. I brought this bill at the request of one of my cities who cannot get them cleaned up, and it poses a constant nuisance to that city. I'd appreciate your favorable consideration of this bill. If there's no questions, Mr. President, I'll yield the will.
There are no questions, Senator. Does any other senator wish to speak for or against the bill? Is there any objection to the agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee shall be agreed to. Shall the main question now be put? Are there any objections? The chair hears none, and the main question is now ordered. Shall the bill now pass? The question is in on the passage of the bill. All those in favor will vote yea. Those opposed will vote nay. Mr. Secretary, if you'll unlock the machines. Senator from the 6th. You always jog in high heels? On the passage of the bill, the yeas are 53 and the nays are 0. This bill, obviously having received the requisite constitutional majority, is therefore passed. Mr. Secretary, please read Bill 403.
Senate Bill 403 by Senators Thompson of the 14th and others. The bill will be titled and act to amend Chapter 2 of Title 21 of the OCGA relating to primaries and elections generally so as to provide for uniform election equipment in the state, to provide that direct recording electronic voting systems shall not be used in primaries or elections in the state after January 1st, 2024. Provide for definition, to provide for ballot marking devices, standards, and procedures for such devices. Provide for audits of election results and for other purposes. Mr. President, Senate Ethics Committee offers the following substitute: Senate Bill 403, a bill entitled and act to amend Chapter 2 of Title 21 of the OCGA relating to primaries and elections generally so as to provide for uniform election equipment in the state. To provide that direct recording electronic voting systems shall not be used in primaries or elections in the state after January 1st, 2024, to provide for definitions, provide for ballot marking devices and standards, procedures for such devices, provide for audits of election results, and for other purposes. That concludes the order.
The chair calls upon the distinguished senator from the 14th to present the bill.
Thank you, Mr. President, members of the Senate. Got a unique opportunity to bring before you a bill that I think everyone in the state of Georgia is interested in, and this will be a little something for everyone, and that is we are taking a look at replacing our voting machines so that every single voter in our state's vote that's cast will be preserved. We've taken into account, I think, just about everybody in this building to make sure we've addressed the concerns. And with that, Mr. President, I'd ask unanimous consent. I'd ask your favorable consent to my bill. If there's no questions, I'll yield the well.
Not so fast, Senator. Chair recognizes the senator from the 41st.
Senator Yield.
I will.
Senator, do you believe it is the intention of yourself and the members of this body to help financially local governments get these equipments when the time comes?
Senator, certainly that's a concern of local governments, and when we get to the point where this is passed, the future Secretary of State, I'm sure, will be able to take that into consideration and help the local governments to make sure we're protecting the votes of the citizens.
And Senator, further yield?
I will.
Don't you think besides having this paper trail, we need to make sure any equipment we switch to or change to is very highly protected from any chance of it being violated online or any voter fraud to be conducted in that manner?
Senator, the current machines that we have are not connected online, nor will the ones in the future. So we are seeking to protect the vote and make sure that we've got an audit trail through paper. That is correct.
Thank you. Just for one more question. The bill, just out of curiosity, the bill doesn't specify an exact brand or exact type of machine. Is that correct? It's more a methodology that has to be in place by a certain time?
You're absolutely correct, Senator. We want to make sure we have a fair RFP. Again, we will leave the future Secretary of State the ability to be able to write that RFP, but one of the things we wanted to make sure, and the committee wanted to make sure, is that we were not narrowing this in any focus. We wanted to allow it to be a fair and open RFP.
There are no further questions, Senator.
Thank you. I appreciate your favorable consideration.
The chair recognizes the senator from the 10th to speak to the bill.
Thank you, Mr. President. I'll be brief. First, let me thank the senator from the 14th for realizing that those of us on the other side of the aisle have been supporting paper ballots for a long, long time. And I think it's long, long overdue that we finally have legislation pending in this body that we all can support and get behind that does exactly that. Though his legislation mentions 2024, we were kind of hopeful that we could, in fact, have something in there so that we could ensure it could be implemented by 2020. But I understand the funding requirements. But again, I rise in support of Senate Bill 403 and ask that we all get behind it and support it. And I certainly appreciate the hard work done by the senator from the 14th on this bill. And I only wish it had a few more Democratic signers on it. Thank you, Mr. President. I yield the well.
Thank you. Recognize the senator from the 29th to speak to the bill.
Thank you, Mr. President. I too will be brief. Just to respond to something the senator from the 10th mentioned, the bill actually has a slightly more aggressive schedule than 2024. If you look in there, what you'll find is there's an RFP process that goes into place in 2019 with the goal of it being fully implemented by the November 2020 presidential election. All I want to say is thank you very much to the senator from the 14th for his very hard work on this legislation. balancing a lot of competing interests, making sure that we have a level playing field for everyone involved, and doing this in a responsible way that gives the state and local elections officials the opportunity to migrate to this new technology. Thank you, Mr. President. I yield the will.
Senator from the 29th, I think you have a question. Senator from the 41st, did you have a question? No, you did not. Senator from the 40th.
Senator Yield. Senator, you spent a lot of time on this issue, have you not?
I have, along with the senator from the 14th.
I didn't get a chance to ask the senator, so if I could, the ultimate cost on this, I know the range was given at one time, I think, to another senator, like $30 to $125 million. My question is, at the end of the day, is the state going to pick up the tab for this if a local jurisdiction does not, or is the state just going to pick it up? What's the plan? I was just curious.
Yes, Senator, that is correct. It would be, as it was during the last statewide contract,
Right.
the state would be responsible. If you look at lines 118 to 121, it is contingent upon the General Assembly specifically appropriating funding.
For you?
Certainly.
So we anticipate no cost to the local governments at this point, that this is a state responsibility.
That is correct. No unfunded mandate.
Thank you very much.
You have a question, Senator from the 14th. You're recognized for a question.
Thank you. Senator Yield?
Certainly.
Senator, isn't it true that you worked with me on this legislation?
Yes, it is.
Senator, isn't it further true that when we worked on this, we wanted to make sure that we gave adequate time to do testing, but at the 2024 was to make sure that we didn't continue to test, but we then moved forward? Was that the reason we put that date in there?
That is correct. The 2024 date is when the audit provisions become mandatory in the bill.
Thank you, Senator.
There are no further questions, Senator. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Shall the main question now be put? Are there any objections? The chair hears none, and the question has been ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor will vote yea. Those opposed will vote nay. Mr. Secretary, if you'll unlock the machines. On the passage of the bill, the yeas are 50, the nays are 1. This bill, obviously having received the requisite constitutional majority, is therefore passed. Mr. Secretary, read Bill 396.
Senate Bill 396 by Senator Schaefer, the 48th, and others. The bill will be titled Enactment in Part 1A of Article 2 of Chapter 5 of Title 46 of the OCA, relating to telephone system for the physically impaired, so as to change certain provisions relating to the establishment, administration, and operation of the statewide dual-party relay service and audible universal information access service, and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 48th to present the bill.
Mr. President, ladies and gentlemen of the Senate, it's my privilege to present Senate Bill 396, which deals with the telephone system operated by the Georgia Public Service Commission for the benefit of the hearing impaired. The legislation before you makes one small change. It allows funds in that program to be used to purchase wireless devices as well as landline equipment. The bill comes with the unanimous do-pass regulation pass recommendation of the Senate Committee on Regulated Industries and Utilities, and I urge your favorable consideration. If there are no questions, I'll yield the well.
Senator, there are no questions. Does any other senator wish to speak for or against the bill? Is there any objection to the agreeing or the report of the committee which has been favorable to the passage of the bill? The chair hears none. The report of the committee is to be agreed to. Shall the main question now be put? Are there any objections? The chair hears none. The main question is now ordered. Shall the bill pass? The question is on the passage of the bill. All those in favor of the bill will vote yea. Those opposed will vote nay. Mr. Secretary, if you'll unlock the machines. On the passage of the bill, the yeas are 48, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Senate Bill 457. Mr. Secretary, if you'll read the bill.
Senate Bill 457 by Senator Tate of the 38th, the bill will be titled and amend Code Section 22-1185 of the OCJ relating to school safety plans, so as to require every public school and private school to conduct drills on the execution of school safety plans based upon guidance from the Georgia Emergency Management and Homeland Security Agency and for other purposes. That concludes the order.
Thank you, Mr. Secretary. We will call upon the senator from the 38th to present the bill.
Thank you, Mr. President, colleagues. This bill is a simple bill. It was brought to me by a young man named Niles Francis, who goes to South Cobb High School. He wanted the bill brought because there are too many instances that are going on around the country that are happening to our young people. He wanted it brought so that they would be prepared in high school. They would know what to do if by some unfortunate reason their school ended up being caught up in one of these situations. It just does, simply does a drill for every public school and private school with the teachers, the students, and other school personnel on the execution of such safety plan, school safety plan, in such form and at such intervals based upon guidance from GEMA and Homeland Security. With that, Mr. President, if there are no questions, I will yield the well and urge your favorable vote on this particular piece of legislation.
There are no questions, Senator.
Thank you.
Does any senator wish to speak for or against the bill? Is there any objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee has been agreed to. Shall the main question now be put? Are there any objections? The chair hears none. The main question is now ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote yea. Those who vote no will vote nay. Mr. Secretary, please unlock the machines. On the passage of the bill, the yeas are 48, the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, if you would read Senate Bill 382.
Senate Bill 382 by Senator Martin of the 9th and others, a bill be titled an act to amend Code Section 4331 of the OCGA relating to definitions relative to optometrists, so as to provide for guidance and consultation by the Department of Public Health on certain training programs approved by the State Board of Optometry for doctors of optometry who administer pharmaceutical agents by injection and for other purposes. Mr. President, Senate Committee on Health and Human Services offers the following substitute, Senate Bill 382. A bill will be titled an act to amend Code Section 4331 of the OCGA relating to definitions relative to optometrists so as to provide for guidance by the Department of Public Health on certain training programs approved by the State Board of Optometry for doctors of optometry who administer pharmaceutical agents by injection and for other purposes. That concludes the order.
Thank you, Mr. Secretary. I call on the senator from the 9th to present the bill.
Thank you, Mr. President. Good evening, colleagues. I rise to present SB 382. This is an administration bill. Last year we passed what we called the Optom bill. This bill codifies, SB 382, codifies an executive order issued by Governor Deal with regard to the training requirements for the new treatment we approved last year. If you have any questions, I will yield for those. Otherwise, I'll yield the well.
Senator, there are no questions.
I ask for your favorable consideration.
The question is on adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Shall the main question now be put? Are there any objections? The chair hears none. The main question is ordered. Shall the bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Those opposed to the bill will vote nay. Mr. Secretary, if you unlock the machines. Suspenseful vote here, Senator. On the passage of the bill, the yeas are 50, the nays are 1. On the passage of the bill, the yeas are 50, the nays are 1. The bill obviously have received the requisite constitutional majority, is therefore passed. Mr. Secretary, if you'll read Senate Bill 431.
Senate Bill 431 by Senator Tiller of the 19th and others. The bill will be titled an act to amend Code Section 51325 of the OCGA relating to certain liability not limited so as to clarify provisions relating to the effect of an owner of land charging an admission price or fee and for other purposes. That concludes the order.
Thank you, Mr. Secretary. Call upon the senator from the 19th to present the bill.
Thank you, Mr. President. Members of the Senate, I bring to you Senate Bill 431. This body, along with the House and the governor many years ago, decided to extend immunity provisions to property owners when they open their property up for recreational purposes. However, the only condition was that those people could not charge for use of their land if they were going to get that immunity. We had a Supreme Court decision that came down that made that a little bit murky. In that case, what happened was there was a provision that allowed children under a certain age to enter on the property for free. Their parents, others were charged. They were also, one of the children was hurt, and the property owner was able to claim immunity under our bill. I do not think that's what our legislature intended at the time, We intended to extend immunity when you were offering your property for recreational purposes and not charging anyone. So what this bill does is tries to take back to the original purpose of the House and the Senate many years ago and clarify that provision. I appreciate your support of this bill, and if there are no questions, Mr. President, I'll yield the well.
There are no questions, Senator.
Thank you.
Does any senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none. The main question is now ordered. Shall this bill pass? The question is on the passage of the bill. All those in favor vote yea. Those opposed vote nay. The secretary will please unlock the machines. On the passage of the bill, the yeas are 43, the nays are 4. This bill, receiving the requisite constitutional majority, is therefore passed. Mr. President, Mr. Secretary, read Senate Bill 404.
Senate Bill 404 by Senator Bassett the 28th and others, a bill be titled and enacted in Part 5 of Article 3 of Chapter 5 of Title 12 of the OCGA relating to public water systems so as to prohibit county, municipal, and other public water systems from charging or assessing a separate fee for standby water service or fire sprinkler system connections and for other purposes. Mr. President, the Senate Committee on Natural Resources and the Environment offers the following subject to Senate Bill 404, a bill be titled and enacted in Part 5 of Article 3 of Chapter 5 of Title 12 of the OCGA relating to public water systems so as to prohibit county, municipal, and other public water systems from charging or assessing a separate fee for standby water service for fire sprinkler system connections and for other purposes. That concludes the order.
Chair calls upon the senator from the 28th to present the bill.
Thank you, Mr. President. Today I present Senate Bill 404. This bill is pretty cut and dry. It just simply says that no municipality, no county, and no public water system can charge or assess a separate fee for standby water service for a fire sprinkler system. It says nothing more, nothing less. With that, I'll yield for questions.
Senator, you have a ton of questions. Stand by.
Sweet.
No questions, Senator.
Amendment.
The question is on the adoption of the committee substitute. Is there adoption of the committee substitute? There is. Beg your pardon. Call upon the senator from the 18th for a question.
Parliamentary inquiry. Mr. President, there's an amendment offered that we'd like to address, please.
You'd like to speak to the amendment?
Please.
Late arriving amendment and the amendment is now being printed. I'd like to recognize the senator from the 18th to, or would you like to speak to the bill, Senator? To the amendment.
I can speak real quick to it. You know, being a common sense guy, I thought it was pretty cut and dry, but our legal minds didn't think it was quite clear enough. So the senator from the 18th has offered an amendment, which I do support. It helps put him at ease. And really, it actually does clear up some question marks that we couldn't work out in committee, but I do support the amendment.
Is there a request, is there a request to have the amendment printed and put on your desk? If there is not, and there's not objection to the amendment, then we will proceed. I can't read it. I'm looking that way. I can't tell. Read it. Yeah.
I'll read the amendment. So, under subsection A, we're adding, after the word fire sprinkler, we're adding the word protection. That's on line 12. So it reads fire sprinkler protection systems. We're also doing that on line 14, fire sprinklers protection systems. But the main part of the amendment is in subsection B. And if I can read this, it says, no county, municipality, or public water system shall charge or assess a separate fee for standby water service for fire sprinkler protection system connections for more than the cost to maintain such connections.
Who offered the amendment?
Senator from the 18th offered this amendment, and I agreed to it.
Senator from the 18th, do you have anything further to add to his explanation of the amendment?
Come down here. I yield the well again.
Thank you, Senator.
Request to speak.
Go ahead. Senator from 53rd, you're recognized.
I had a question for the young gentleman from wherever he's from. So, you can take a question? Hey, look, it's good. Coweta County. Thank you, my dear. It's a friendly question.
I unyield the well.
Senator Yield.
Of course, Senator.
Look at here. Isn't it true that this is a bill brought to you by the fire chiefs?
Correct.
All right, that's all I want to say. Thank you.
Senator, you have a plethora of questions now. Senator from the 41st, you're recognized for a question.
Senator Yield?
Yes, Senator.
Has the Municipal Association taken a stand, or ACCG taken a stand on this bill?
The GMA and the water authorities were against. We tried to work out an agreement on it. We could not. We proceeded. And actually, I do think the amendment would help address some of the Water Authorities Association's concerns.
So your answer is no, they don't support it, but this may address some of their concerns.
Correct. I know that's a shocker, but GMA did not support it.
Senator Further Yield, is it possible that even though you may say you can't charge for standing water, that the probability is in some way the water system is going to find a way to make themselves whole, so they will pass cost on in some manner to other consumers or through the system? They're going to be, they're going to get their money to do their job. Is that not correct?
They are still allowed to charge for the maintaining of the equipment, for any sort of infrastructure cost. They are still able to do that. They simply are not able to charge for water that is just sitting in a system. And we asked well, you were in committee, Senator, but we asked Ledge Council to give us a ruling on that, and I think they were very clear.
Senator from the 45th, you're recognized for a question.
With Senator Gill.
I do.
Senator, is it not true that I didn't have the purview? I don't sit on that committee. Is that not true?
That is true.
But would you further yell?
Of course.
Is it not true that when cities and counties, local governments put in pressures for water systems, that they have to put in collateral infrastructure that cost a lot of money, and all they're redoing is recouping their cost, their capital cost? Is that not true?
That is true, and they're still allowed to do that.
Would you further yell?
I do.
If they charge ancillary services money for those costs, and their rate structure and their bonding is already set on that, are you not disrupting that system?
I don't know the answer to that, Senator. I don't believe I am, but if
Would you further yield?
I do.
Is it not true that if the Municipal Association, and I don't know if ACCG, the counties are opposed, that you're actually overlaying and intruding on the way that they currently do business? Is that not true?
if that's what you say, madam.
Senator from the 19th, you're recognized for a question.
Thank you, Mr. President. Senator Yield.
I yield, but I'll remind y'all this is not my first bill.
Thank you, Senator, for reminding me of that. My question, do you have any examples of fees that have been being charged for connections?
For connections?
Right. This bill seems to address connections, and I was wondering if you had examples of exorbitant fees that may have been being charged. Do you have any examples of any fees that are currently being charged?
I do not.
Senator from the 23rd, you're recognized for a question. Senator from the 23rd, if you will get to your seat. What is your inquiry? We'll let the gentleman in the well finish before the parliamentary inquiry, if you'll stand by.
If there's no further questions, I'll yield the well.
Senator, you're certainly welcome to yield the well. You have questions, but you're welcome to yield. You do? Okay. Senator from the 36th, you're recognized for a question. Senator from the 32nd, you're recognized for a question. Got a friendly question here, Matt.
Did the gentleman yield the well?
Senator from the 32nd, you're recognized. You're recognized.
Will the senator yield?
32nd.
I yield.
Just a question about would the additional cost be passed along to the ratepayers?
That is not the intent of the bill. The intent of the bill is to not allow for the charge of water sitting in a system. Once that water is sitting in the system, you can no longer charge for that water. That is the only intent of the bill. That is what Ledge Council ruled on, and you can twist it any way you want, but if you will simply read the bill, it simply says you cannot charge for standby water service. That's it. We've overcomplicated this thing like we do too often in government.
We have one final question, Senator from the 36th.
Mr. President, this is Senator Yield.
I yield.
You know, many of the questions that you're getting, I think, isn't it true, like mine, are coming because our local water authorities and local governments are sounding the alarm that there could be unintended consequences to this legislation. And you've referred a couple of times to Ledge Council having a ruling. We don't know what that ruling or finding was. That might help, but there's a sense, for my part, a real unreadiness to support this legislation if it's going to burden ratepayers. And in Atlanta, we pay very high and dear prices for our water per cubic foot. So could you shed some light on the legislative council ruling?
Yes, ma'am. In committee, I asked for Ledge Council to give us a ruling on exactly what the bill as written, what did it mean? Did it mean that they could not charge a base rate? Did it mean they could not charge for infrastructure? Or did it simply say they cannot charge for water sitting in the system or waiting to be charged into the system? And the ruling came, they said right then and there in committee that as they read this bill, it simply says you cannot charge for water either in a system or waiting to be entered into the system. Has nothing to do with infrastructure or anything like that, or even the maintaining of the equipment, any of that.
But it says, the language on line 13, it says no county, municipal, or other public water system shall charge or assess a separate fee for standby water service. I mean, the way we're billed on our water is what runs through the meter. So
they can still charge for that meter, and they can still charge to maintain that meter. They simply cannot charge for water sitting in the system doing nothing.
But they've sold that water to the I mean, that water costs the taxpayer. We clean
Once
the
they
water.
sell it and it enters that system, then they can't keep charging for it sitting in the system.
Well, maybe we don't understand the problem that you're trying to cure. The charging for sitting in the system. The charges roll up when it runs through the meter. Isn't that right? I mean, I'm not, as you well know, I'm not an engineer or a hydrologist, but it seems like there's genuine concern
Understood.
at local government level on this. Thank you.
Senator from the 31st, you're recognized for a question.
Thank you, Mr. President. Does the senator yield?
I yield.
On your amendment, it seems to say that you strike lines 12 through 14 and replace it with this language. And then it leaves line 15 there, which seems to be kind of out of order. Is there a problem drafting this amendment?
I'm going to let the senator from the 18th speak to the amendment.
Thank you.
Senator from the 26th, you're recognized for a question.
Gentleman in red, will the senator yield?
Yes, sir, I yield.
As I understand it, isn't it true that what the senator from the 18th is doing is allowing a recouping of the fees that whoever the water provider is to check on the gauges? What we're talking about in standing water, you're talking about an apartment building or a building that has a sprinkler system in it, but you very seldom use the sprinkler system unless there's a fire.
That's correct.
But the system has to be checked by the water department, and they got gauges on. They have to check to make sure that the pressure is right, so that when the system does come on, there's enough pressure to send the water to the sprinkler system. Isn't that correct?
Correct, and they're still allowed to charge for that. Just so I'm clear, the idea behind this whole thing is to encourage more residential and more commercial to install these fire sprinkler protection systems. As is to save lives and save property. With that, I'll yield the well.
There are no further questions, Senator. Thank you. Senator from the 18th, you're called to speak to the bill, to the amendment.
Thank you, Mr. President. Good afternoon, colleagues. I think I can address what the purpose of the amendment is, and I think it will address most of your concerns, if not all of your concerns. I, too, had some calls from folks back home with water systems from my municipalities. They were concerned about the bill. So if you look at the amendment that's being offered, all it does, and the first part of actually this, I think the author of the bill is fine with this. It adds the word protection between fire sprinkler and systems on line 12, and it does the same thing on line 14. That is of no substantive difference in the bill. However, what does change is the addition of about 9 words at the very end, which adds for more than the cost to maintain such connections. So what is the meaning of that? What does that mean? If you read section B, it says, no county, municipal, or other public water system shall charge or assess a separate fee for standby water service for fire sprinkler protection system connections. But once you add for more than the cost to maintain such connections, then that provides the balance and the protection for the municipality. That allows the municipality to continue to charge for the connection, but not more than the actual cost. I think this strikes a fair balance. What does it protect against? The church or the business is getting a $300 a month connection fee for their fire sprinkler system, but there's no water going through it. The landowner thinks, wait a minute, there's no water going through it. Why am I being charged? But the municipality says, well, it's not fair that we have to provide the infrastructure in case you need the water. So they want to charge some fee. But there's not a usage fee because water's not flowing through the pipe, so you can't attach a meter to it and charge what you normally would. So I think this strikes a fair balance. It allows the city to charge for the cost to be able to provide that water, but no more than that. And quite frankly, the municipalities should not be charging more than what the cost is to be able to provide the water. Conversely, they shouldn't, the landowner shouldn't demand that the fee be $1 or $2 if in fact it costs the city $25 a month to provide that infrastructure. So I think the addition of this language at the end provides that balance so that the municipalities can charge for the connection, but there's a check on it so that they're not charging more than the actual cost. I'll be happy to answer any questions. Mr. President?
There are one question. Senator from the 45th. You're recognized.
Parliamentary inquiry.
What is your inquiry?
Excuse me?
Go ahead, sorry.
Parliamentary inquiry.
What is your inquiry?
If you would please yield, my question is, I understand about the connections and the flow not going through, but the counties and the cities have to provide the infrastructure for the pressure of the water, for the ISO rating, for the insurance rating. So my question is, yes, the water's not flowing through, but if there is a fire, you have to have the certain amount of pressure and the infrastructure to support it to make it come through. So no, there is no water coming through, but they have to develop all that and spend that capital money and the bonds, and if these are authorities, in case you do have to use it. So all they're doing with that $300 fee is paying for that infrastructure to get that pressure up. Is that not true, or am I not understanding it?
Senator, I don't think you quite understand. To answer the last part of your question, if in fact the cost to the municipality to provide the infrastructure for the service to be provided to property A were $300 a month, then they can charge $300 a month. We both agree you can't meter this, right, because there's no normal usage, right, and you can't charge for the commodity being sold, which is water, because it's not flowing. You're not selling the water. It's a providing of the infrastructure so that the water can be provided in the event of an emergency. So with your example, I believe under this language the municipalities can charge for that cost of infrastructure, which would include the things that you spoke of, those things necessary to have the water pressure at level X, the piping necessary to get it from the main line to the facility that needs this for fire sprinkler protection services. I think everything that you spoke of would be encompassed in the cost to maintain such connections, which is the critical language, the last 5 words of the amendment.
Senator from the 40th, you're recognized for a question.
Senator Yield?
Yes, sir.
Senator, I think you just answered it. Is it not true that when you said the key language here is for the cost to maintain such connection, and that's what you're trying to do in order to have the pressure when you need it, whatever it costs in order to maintain such a connection, that's what you're trying to cover. Is that right?
That's right, Senator.
Okay,
exactly.
Thank you very much.
Senator from the 53rd, you're recognized for a question.
Mr. President, Senator Young.
I yield.
Isn't it true that the infrastructure in a facility, an industry, an apartment complex, at your home is paid for by the owner of that facility?
That's my understanding,
Okay,
Senator,
that would
yes.
be, the answer is yes.
Yes.
Isn't it true that if a city or county or water authority didn't maintain pressure, when you turn the faucet on any of those locations, there'd be no water coming out?
I think that's right, Senator.
So isn't it true that their responsibility is to provide pressure for any of their systems? Answer would be yes.
The answer is
Thank
yes
you.
with this qualifier, Senator, and that is if, in fact, in the event of a fire, the quantity of water that was needed at that moment could be so great that it would lower the pressure. And so I don't know what systems, I'm not an engineer, I don't know what systems would be needed to maintain both the pressure and the quantity for the flow of water necessary to be provided. Yes, sir.
No more questions, Senator. Thank you very much for bringing clarity to this issue.
Thank you, Mr. President. I yield the well.
Senator from the 36th. She's waving off. Senator from the 19th.
Sorry, Mr. President.
State your inquiry.
Does this amendment create a committee sub pursuant to Senate Rule 6.7?
6-7.1.
It does not.
Thank you.
The question's on the adoption of the amendment. Is there objection to the adoption of the amendment? Hearing none, the floor amendment is adopted. All those in favor of the adoption of the amendment from the senator from the 18th? It's adopted. The question now is adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute is adopted as amended. All in favor? The question is now to be put. Are there any objections? The chair hears none. The question is ordered. Shall the bill pass by substitute? The question is by the passage of the bill by substitute. All those in favor will vote yea. Those opposed will vote nay. Mr. Secretary, if you'll unlock the machines. Praise the Lord. Senator from the 56th, why do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Isn't it true the senator from the 53rd and myself both have extensive knowledge in this area, and we know that there should not be a charge, and this is really a good bill to protect business owners, because we're a business-friendly state. Is that not true?
The senator from the 56th knows of what he speaks. And they're both high-pressure individuals. Parliamentary inquiry coming from the back left field.
Should the bill read passage by substitute as amended?
Yes, it should. On the passage of the bill, the yeas are 34, the nays are 14. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, if you'll read Senate Bill 391.
Senate Bill 391 by Senator Beach of the 21st. The bill will be titled an act to amend Part 1 of Article 2 of Chapter 10 of Title 32 of the OCGA, relating to general provisions relative to the State Road and Tollway Authority so as to exempt transit service buses, motor vehicles, and rapid rail systems from requirements relating to identification and regulation of motor vehicles and for other purposes. Mr. President, that concludes the order.
Recognize the senator from the 21st to present the bill.
Thank you, Mr. President. Fellow senators, I bring before you Senate Bill 391. It's a State Road and Tollway Authority bill, a CERTA bill. And what's happened is CERTA has assumed responsibility for the Greta Express bus service. So all this bill does is it takes the language that was in the Greta code and it mirrors it in the CERTA code. And this language simply exists CERTA from three things: paying to register their buses, preparing logbooks, and certain Department of Public Safety inspections. DPS does not object to this request, and CERTA is working closely with DPS on a variety of safety and inspection issues. Mr. President, if there are no questions, I will yield the well and ask for your favorable consideration on Senate Bill 391.
There are no questions, Senator.
Thank you.
Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the favorable committee substitute for the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote yea. Those opposed vote nay. Mr. Secretary, if you would unlock the machines, please, sir. On the passage of the bill, the yeas are 41, the nays are 4. This bill obviously receiving the requisite constitutional majority is therefore passed. Mr. Secretary, if you would read Senate Bill 236.
Senate Bill 236 by Senator James of the 35th and others. The bill will be titled an act to amend Code Section 46-391 of the OCGA relating to driving under the influence of alcohol, drugs, or other intoxicating substances. Penalties, publication of notice of conviction for persons convicted for a second time and endangering a child. So it is required that the County Department of Family and Children's Services be notified when certain offenders are convicted for endangering a child by driving under the influence of alcohol or drugs and for other purposes. Mr. President, Senate Committee on Judiciary offers the following substitute Senate Bill 236. The bill will be titled an act to amend Code Section 46-391 of the OCGA relating to driving under the influence of alcohol, drugs, or other intoxicating substances, penalties, and endangering a child, so as to allow the County or District Department of Family and Children's Services to be notified when certain offenders are convicted of endangering a child by driving under the influence of alcohol or drugs and for other purposes. Mr. President, that concludes the order.
Call upon the senator from the 35th to present the bill.
Thank you, Mr. President. Senators, I appreciate the opportunity to offer Senate Bill 236 for your consideration. It is a bill that will provide for the county's Department of Family and Children's Services to be notified when a person who is driving under the influence is convicted and he is a parent or a guardian and has children in the car. And so this would offer the prosecuting attorney an opportunity to send a copy of that traffic citation so that that person will have a file with defects. If there are no questions, then I yield the well.
Senator, you may yield the well. There are no questions.
Thank you. I yield the well.
The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. All those in favor? Any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The committee hears none. The chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none. The main question is now ordered. Shall this bill pass by substitute? The question is on the passage of the bill by substitute. All those in favor will vote yea. Those opposed will vote nay. Mr. Secretary, if you'll unlock the machine. On the passage of the bill, the yeas are 50, the nays are 0. This bill receiving the constitutional majority is therefore passed. What do we have? Mr. Secretary, read Senate Bill 430.
Senate Bill 430 by Senator Brass of the 28th and others. The bill will be titled an act to amend Title 15, Chapter 2 of Title 21 and Chapter 5 of Title 40 of the OCGA relating to courts, primaries, and elections generally, and ad valorem taxation of property, respectively, so as to modify the compensation of various local government officials and for other purposes. That concludes the order.
Call upon the senator from the 28th to present the bill.
Thank you, Mr. President. Today I bring you Senate Bill 430. Simply does 5% raises for our constitutional officers along with a cost of living adjustment. I've placed on your desk what your current minimums, or actually what your current salaries are for each constitutional officer. You'll learn we're simply only raising up the minimum. Very few counties are affected. The counties that are affected, we're only talking about a couple $1,000s here and there, and the bill does not take effect until 2021, so they've got 3 years to make those adjustments. So that's pretty much it. If you have questions, I will certainly yield.
Senator from the 41st, you're recognized for a question.
Senator Yield.
I yield.
Senator, these pay raises, do you know how they would compare to the national average for these positions?
I do not. I do not have that data before me.
Senator, further yield.
I yield.
Is it not true that many members of this body are not only concerned about these individuals you brought forth, but also other individuals in the state? Don't you think we should be raising all state employees' raises, and we should try to support local governments to raise employees up to the monies that they deserve?
I would love to. This bill does not deal with that. We have done raises in the past, and it needs to be noted that these constitutional officers have not seen a raise in 12 years. And we're simply just raising up the minimum.
Senator Ferdio, do you know when the last raise is that they've received?
I'm sorry, repeat the question. I can't hear you.
Do you know what the time of the last raise that they legislatively received, when the last time we raised the base amount up?
It is my understanding it was 12 years ago.
Thank you. Senator, do you have any idea what the inflation has been over the last 12 years? How much they've slid in economic purchasing power?
I know that it's more than what we've given them, which is zero.
Thank you. And during that time, other employees of both state and local governments have seen their economic purchasing power slide, but they haven't received raises. Is that not true?
That is true.
Thank you, Senator, for your work on this issue.
You're welcome.
Chair recognizes Senator from the 18th for a question. 18th. 18th. Nope. Waves. No further questions, Senator.
Thank you.
Nope. Waves off. Does any other senator wish to speak for or against the bill? Is there objection to agree in the report? Chair recognizes Senator from the 41st. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
Is it possible the Senate could give a second? The senator from 26 is preparing an amendment to this bill and would like a chance for it to be considered. Late arriving amendment. Slow turtle time down to the front.
Secretary is saying that the previous question has been ordered. No, I mean, it's still that you can ask a parliamentary inquiry. Senator from the 26th, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true we qualify next Monday?
Hold on. Quieting down in the chamber. I couldn't hear you. Say that again a little slower.
I say, isn't it true that we qualify to run for office next Monday?
We qualify
Next
for,
one.
I think everyone qualifies for office. Yeah, qualifies to run for office.
Mr. President, and it also true, we talking about giving folks pay raises, but I don't see one in here for the members of the General Assembly. And isn't it further true that there was a commission that was put together and made the suggestions on pay raises for constitutional officers as well as members of the legislature?
So I'm sure the senator knows from which he speaks.
Parliamentary inquiry.
State your inquiry.
Mr. President, then would it not also be fair that if time were given to make an amendment to this bill to make sure that members of the legislature were compensated fair too?
Senator has great passion for which he speaks.
Mr. President.
Yes, Senator.
Would it be all possible to get you to indulge in writing an amendment to make sure that your members will be able to be compensated since you are leaving us and you're going to get compensated well?
Well, Senator, you know I love every single member of this body. And I know how hard everybody works as a senator, and I know that you have great passion for which you speak, and you are right. This will be my last year as the Lieutenant Governor of the great state of Georgia. So you are correct. Sadly enough, the question has already been ordered, so unfortunately we're not going to be able to have the amendment by which you are requesting, but it does not impact the love and the admiration and the respect and the appreciation that I have for you, Senator.
A parliamentary inquiry. We're not going to have a love fest here, but
but
isn't it true?
Enjoying it.
But isn't it true?
Yes,
that
I'm
love,
sure it is.
Isn't it true that love goes out the window when you can't pay the bills?
A lot of truth to that, Senator. A lot of truth to that. A lot of truth to that. Is there objection? Agree on the report of committee which failed pass the bill. Chairs none. Report of committee is agreed to. All those in favor of the bill will vote aye. Those opposed no. Secretary will unlock the machine. Great to have our Atlanta Public School System Superintendent with us today. Maria, thank you very, very much. Good to have you. Appreciate the good work you are doing, visiting us here in the Senate. On the passage of the bill, the yeas are 51, the nays are 3, and this bill, having received requisite constitutional majority, is therefore adopted. Just for planning purposes, about 6 o'clock, we'll take our supper break. Secretary will read Senate Bill 358.
Senate Bill 358 by Senator Rudd of the 33rd and others. The bill will be titled Enactment Chapter 60 of Title 36 and Code Section 45.814 of the OCGA relating to general provisions relative to provisions applicable to counties and municipal corporations and depositories for county and school district monies, respectively, so as to provide for the establishment of banking improvement zones and for other purposes. Mr. President, the Senate Committee on Banking and Financial Institutions offers the following substitute Senate Bill 358, a bill be titled Enactment Chapter 60 of Title 36 of the OCGA relating to general provisions relative to provisions applicable to counties and municipal corporations so as to provide for the establishment of banking improvement zones and for other purposes. That concludes the order.
Chair recognizes the distinguished senator from the 33rd. Present the bill. He's been a busy man today. It's his second bill. Beautiful bipartisan action occurring in the Senate today.
Thank you, Mr. President, my fellow senators, colleagues, friends, and y'all. Today I'm here to talk with you about Senate Bill 358, a banking improvement zone. This bill provides for the creation of banking improvement zones. The Department of Community Affairs may designate these zones within the jurisdiction of a local government to encourage the establishment of branches or representative office of a bank in the areas that are underserved by banking services. In evaluating an application to create a banking improvement zone, the Department of Community Affairs should consider the following: the location, number, and proximity of sites where banking services are available, consumer needs for banking services in the proposed banking improvement zone, the economic vitality and local credit needs of the local government, the existing commercial development, and the impact of additional banking service will have on economic potential. After a banking improvement zone is approved, the local government may designate by resolution or ordinance a bank to be located in the zone as the depository for local government funds. This resolution or ordinance will also designate a fixed interest rate that is at or below the posted 2-year certificate of deposit rate at the bank, subject to an agreement between the local government and the bank. Before any banking improvement zone can be created, the Department of Community Affairs must make a determination as to whether the potential gains from this below rate interest agreement can be considered ample consideration for substantial public benefit in compliance with the gratuity clause of the Georgia Constitution. And if there are any questions, Mr. President, I'm ready to entertain them.
You did such a good job. There's not one member of this body that has a question for you.
Thank you, sir. I yield the well.
Questions on the adoption of committee substitute. Is the objection? Without objection, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is the objection agreed and report of committee which fail will pass the bill? Chairs none. Report of committee is agreed to. Shall the main question be now put in the objection? Chairs none. Main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill, vote aye. Those opposed, no. Secretary, unlock the machine. On the passage of the bill, the yeas are 52 and the nays are 1. And this bill, having received requisite constitutional majority, is therefore adopted. Secretary now will read Senate Bill 444.
Senate Bill 444 by Senator Unton, the 45th and others. A bill will be titled Enactment, Chapter 6 of Title 49 of those GA, relating to services for the aging, so as to create the Georgia Alzheimer's and Related Dementia State Plan Advisory Council and for other purposes. Amendment 1 by Senator Walker, the 20th and others, offers the following amendment. Amend Senate Bill 444 by inserting after requirements on line 4 to provide for a short title by inserting after line 8 the following. This act shall be known and may be cited as the Senator Thorburn Rostall Senate Jr. Act and for other purposes. Mr. President, that concludes the order.
Chair recognizes the distinguished senator from Gwinnett County, senator from the 45th.
Thank you, Mr. President. I bring before you Senate Bill, what? The amendment. There's an amendment?
Yeah, there's an amendment. Ross Collison,
Yeah.
you're just speaking to the bill.
Thank you. Ladies and gentlemen of the Senate, Senate Bill 444, I'm speaking to the bill. And as you know, we have worked on Alzheimer's for many, many years now. It's been my pleasure to work with the particular advocacy groups in the Department of Human Services. I'd like to especially thank Commissioner Robin Crittenden, who is over DHS. She's done a fabulous job along with the Division of Aging and all of the aging advocates. We have started on this journey several years ago, and what's so interesting about it, and I would like to just speak to the amendment for a second. Senator Ross Collison was my suite mate, and he's an early riser. He's a farmer, and I was a nurse, so I get up early and he gets up early. And I'll never forget, because he was my suite mate right next door to me, and I would come in and every morning we'd have coffee together and we'd chit-chat together. But I noticed in the last year that he was here, I would walk by his office and he would just be staring at the television, and the television wouldn't even be on. And I knew that something was going on, but I just couldn't put my finger on it. And I have to tell you, it was for all of us that had served with Senator Tolleson, it was a very, very difficult task to learn what was happening with him. So the whole time that we were working on the Alzheimer's, this was occurring with my suite mate. And it's very fitting that the senator from the 20th came up with just very nice remembrance in the honor of naming this bill after him. And we call it the Guard Group, and we have been meeting. We meet quarterly, and there's about 20 people. It's an open meeting. We meet with the House and the Senate, and all this bill does is solidify what we're doing and codifying what we're doing, and it creates a statewide action plan. And if you look at the number of people, the baby boomers that are growing with related dementia disorders, I think it's very fitting that we are prepared and we're ready. And it is just so touching when we know that one of us may be the next one that has dementia. And maybe some of y'all are taking care of family members that have dementia. So it's just my honor to be able to stand here and bring before you Senate Bill 444, and to thank all those advocates, to thank all those senators and representatives through all these years that have worked on that. If there's no questions, I'll be glad to yield the will, and I ask for your favorable consideration of Senate Bill 444.
Thank you, Senator. Chair recognizes Senator from the 20th speak to amendment number 1.
Thank you, Mr. President. It's a real honor for me to offer this amendment today. I've known Senator Tolleson, Ross, as we know him in Perry, my whole life. I've never met a person with a more positive attitude. I don't ever remember seeing him when he didn't have a smile on his face. Very energetic, very likable person. Of course, he served in this body from 2003 to 2015. He was my predecessor in representing District 20. Ross's health, unfortunately, is declining, but he still has that smile on his face and that positive attitude. I have been able to spend some time with him. Recently, we've traveled to Dublin together at the end of last year and just had a really good time. Had lunch with Mayor Phil Best over there and some of his other old friends from Dublin. Had a great time. I saw him around Christmas time. I gave him one of those Senate pullovers, and he just beamed. And so he has still got that great attitude. Also, they have a wedding coming up. Ansley Tollison is getting married in a few weeks, so I know that'll be a great occasion for the Tollison family. I talked to Sally this morning about this. She was very touched and thought it was very appropriate, and she's wanted me to thank the Senate for this. So my amendment names this bill the Senate Thorburn Ross Tollison Jr. Act, and I appreciate the chair lady for allowing me to do this. Thank you.
Thank you, Senator. The question now is on amendment number 1, authored by the senator from the 20th who just spoke to the amendment. Is there objection? Without objection, amendment number 1 is adopted. Does any other senator wish to speak for or against the bill? Is there objection agreed and report of committee which fair will pass the bill? Chairs none, report of committee is agreed to. Shall the main question be now put? Of the objection, chairs none, main question is ordered. Shall this bill now pass as amended? Question on the passage of the bill is amended. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. Chair recognizes Senator from the 53rd.
Parliamentary inquiry.
State your inquiry.
Mr. President, it is true when we vote for this bill, it will now be named after our beloved friend, Senator Ross Tollison Act.
You have it correct, Senator. Good man. Was probably one of the hardest working senators we have ever known. Chair recognizes Senator from the 49th.
True, if Ross Tollison were here today, he'd say, tighten up.
Tighten up, that's right. He would. All right, very good. Yeah. Thank you, Senators. Very nice, unanimous vote. On the passage of the bill, the yeas are 55, the nays are 0, and this bill absolutely erects constitutional majority is therefore adopted. Secretary will now read Senate Bill 420. 420.
Senate Bill 420 by Senator Redd of the 33rd and others. The bill will be titled an act to amend Article 1 of Chapter 1 of Title 31 of the OCGA relating general provisions regarding health so as to require certain health clubs in the state to have at least one functional automated external defibrillator on site at such facility at all times for use during emergencies and for other purposes. Mr. President, the Senate Committee on Health and Human Services offers the following subject to Senate Bill 420, a bill will be titled an act to amend Article 1 of Chapter 1, Title 31 of the OCGA, relating general provisions regarding health services requires certain health clubs in this state to have at least one functional automated external defibrillator on site at such facility at all times for use during emergencies and for other purposes. Amendment 1 by Senator Burke of the 11th and others offers the following amendment to the Senate Committee substitute to Senate Bill 420. By striking 250 on line 23, replaced with 500. Mr. President, that concludes the order.
Chair recognizes the senator from the 33rd again. I mean, he's got more well time today than any other senator, I think.
Thank you, Mr. President, fellow senators, colleagues, friends, and y'all. Today, I want to talk with you about Senate Bill 420. It requires that every health club with 250 or more clients in the state to have at least one functional AED on site at such facility at all times for use during emergencies. This bill also provides tort immunity for individuals using the defibrillator. The legislation requires by July 1st, 2019, that each club in the state have at least one working AED on site that is easily accessible during business hours. The health clubs are required to ensure that persons authorized by the club to use the AED complete an American Heart Association or American Red Cross training in cardiopulmonary resuscitation. It ensures that the AED is maintained and tested according to the manufacturer guidelines and ensures personnel activate the EMS system as soon as possible after a person uses the AED for someone in cardiac arrest and report any clinical use. The Department of Health is authorized to enforce this compliance to this section and may inspect a health club at any reasonable time. An inspection must be made in response to a complaint alleging noncompliance with this section. The Department of Health can also adopt rules requiring a health club to have more than one AED based on the size and number. Also, as I said earlier, this bill provides immunity from civil liability for providing emergency care or treatment by using the AED machine at a health club. Mr. President, there is a substitute, a friendly substitute, and I have no problem with that. If there are any questions, I'm ready to take them on before we eat.
There are no questions, Senator.
Thank you, Mr. President. I yield the well.
Correct. We have amendment number 1 I'd like to get spoken to. Chair recognizes Senator from the 11th, then the Senator from the 56th.
Thank you, Mr. President. During the discussion in committee on this bill, one of the concerns was trying to not overburden the small businesses in the rural and metro areas, for that matter. And so this friendly amendment just replaces the number of customers that this health clubs have to 500. Be glad to answer any questions if there are any. If not, I'll yield the well.
Chair recognizes Senator from the 56th. Speak to the bill.
Thank you, Mr. President. I want to thank the senator from the 33rd for his noble effort here today. But I want to offer a little context of what this bill is going to do. We're going to tell a business that you must go spend money and buy a piece of equipment based on our perception that people who go to a workout facility are more likely to have a heart attack, and that is actually the exact opposite. In fact, your chance of having a heart attack is 5% while doing exercise or working out. Your chance of having a heart attack while you're sitting on your couch is 95%. So I want you to think about this for a second. If we're going to start mandating every business have a defibrillator, which is a great device, which I have personally used before several times, then we ought to mandate every shopping mall, every office building, every gathering of people that has a large group of people. So we have to think about what we're doing here. Is it the rule of the Georgia Senate to take every business based on a perception and force something upon them that doesn't even meet the metrics of what happens when people have heart attacks? We come here and we do a lot of good work. This would not be one of those. I'd urge you to vote no, and let's go back and look at how we can improve first responders, emergency response, and things of that nature. But if you're going to vote yes to this today, thinking we're going to help more people out, the opposite would be true. So I would urge you vote against this. If there are no questions, I would yield the well.
There's a couple of questions. First up, the regular Jim Rat from the senator from the 11th.
Thank you, Mr. President. It takes one to know one. You know, we in medicine are very careful when people throw out numbers, and I'm a little bit suspect about your number. I mean, I think if we looked at the amount of time that Americans spend on the couch versus how much time they spend in the gym, that your number is probably correct, but probably not statistically significant. Would you yield for a question now that I'm through with my comment?
I would love to yield for a question, Doc.
Do you think it's not true that most gyms, from the standpoint of protecting themselves from lawsuits, that are large commercial gyms, would already have an AED present just for their own protection as well as the protection of the people that work out?
Senator, I think that many facilities have them. Many office buildings have them. We have one on the other side of this door here. I would encourage anybody who thinks there's a need to not only have a defibrillator, but to have an entire first aid kit and to provide training to the personnel around that. But that doesn't mean we as a state should mandate them to do that. Thank you for your question.
Senator from the 10th is recognized for another for a question.
Thank you, Mr. President. Would the Senator yield?
I will yield.
Senator, is it the cost of one of these devices that you're concerned with, or just the fact that this legislation would create a mandate for those that serve more than 500 people?
Well, I think it would be both, Senator. I appreciate your question. You know, whether we were going to mandate they pay $10 for something, $1,500 or more, why is it the role of this body to tell a business what they should have in their place of business? You know, if we followed that logic out, we could start mandating just about anything for any business.
Senator, yield?
I yield.
Senator, on these devices, you can pick one up for a couple of $100.
Well, Senator, the typical one is quite a bit more. And again, I'm a fan of the device itself. And if a business wants to buy one because they feel it necessary to, I have one in my office, then we should do that in my business office. However, again, is it the role of this body to mandate? I think that's where I see the separation.
Senator, further yield?
I do.
Senator, aren't you familiar with OSHA?
I am very familiar with
Doesn't OSHA mandate that certain businesses have certain safety requirements depending on an occupation?
OSHA does have certain safety requirements for large machinery and other things of that nature, but this does not pertain when somebody's ability to have a heart attack is 5% there versus 95% when they're not exercising. So while I appreciate you bringing up OSHA, those are apples and oranges.
Thank you, Senator. I
Thank you.
disagree.
No further questions, Senator.
Thank you. I yield the one.
Chair recognizes Senator from the 33rd. Close the debate.
Thank you, Mr. President. In closing this discussion, I just want to talk about my personal experience. Retired about 2 years ago from the Air Force Reserve, and one of my jobs was to manage fitness and health for the pilots and navigators. And part of my training was to learn how to do CPR and also use a defibrillator. Also, currently am a lifeguard in Cobb County through the Cobb County Aquatic Centers. I'm one of the I am the oldest lifeguard in Cobb County. And once we get out of session, I have to renew my certificate. But I can tell you numerous times how having a defibrillator nearby has saved people's lives. I remember one time we were in the gym working out, and somebody had a cardiac issue. And in the gym, there wasn't a defibrillator. So we ran across the street to the public library, and then we got their defibrillator and came back and saved and stabilized the person. You don't realize how important these things are until you have to actually help somebody restart their life. A lot of us here know how to restart a car, but to restart a life, a lot of us are not familiar with that. But these defibrillators are friendly user. I mean, when you press the button, it says, press button, stupid, open up, move back, shock. So as you know, we have defibrillators here. So I emphatically encourage you to consider this bill because it can save a life. And if you can help us with this, we'd really would appreciate it. Thank you so much. I yield the well.
Thank you,
Unless
sir.
there's any questions.
No questions. Question now is on amendment number 1, authored by the senator from Bainbridge. Is there objection? Without objection, amendment number 1 is adopted. Question now is on the adoption of the committee substitute as amended. Is there objection? Without objection, committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree to report of committee which fail will pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. Chair will recognize Senator from the 13th for an announcement.
Thank you, Mr. President. Ladies and gentlemen, please don't forget this is crossover day. We're about to break for dinner. You want to cross over to the depot and have some fish, fried fish by Cordial, so please come and join me, okay?
Knows how to tempt a man. Cordial. On the pass of the bill, the yeas are 42 and the nays are 11. And this bill, having received requisite constitutional majority, is therefore adopted. We will take our supper break now and we'll report back here at 7 o'clock. No, hold on 1 second. Wait. Chair recognizes Senator from the 11th again for an announcement.
13th, but I'll announce anyway. There's a special line for legislators, so we're going to get you in and get you out quick, so we won't take up your time. Thank you, Mr. President.
All right, very good. Thank you. Read the announcement.
Rules will have a meeting at 6:30 at 450 of the Capitol. That concludes the order.
6:30 rules. We'll be back here at 7 o'clock sharp, please.